also became an instructor for pepper sprays. Pepper spray, again, just similar to impact weapons, has a basic operator certification course, and I went to the trainer's course to teach the basic course. That course involves proper deployment, target areas, and so forth. In a similar nature as you do with the impact weapons, it's just a lower level on the force continuum that's evaluated by those being either using it or evaluating its use. So my instructor certifications while at the City of Riviera Beach were the initial instructor level courses.
You had mentioned a term that I presume is going to come up in your future testimony here today, so I want to ask you to explain it to the jury. A concept of a force continuum. Explain to the jury what that is.
It's basically, a force continuum is a systematic approach to the escalation and de-escalation of force options. It's basically looking at an event and saying that all events start, for example, with somebody being present. So that would be one of the first things that you would look for as you begin your evaluation. Who was there, how many were there, so on and so forth. You evaluate each and every level, and you have to break it down for both the aggressor, and you have to break it down, in law enforcement terms, it's the aggressor or your subject and the officer. In civilian terms, it would be the aggressor and the defender. Okay, and what you do is you look at the various levels of options that are available to that individual, taking into consideration a wide variety of topics, ranging from personal information, subject factors like their age, their height, their weight, things like that, moving through background, training, experience, weapon availability, environment considerations. All these things come into a force continuum, which is a structured way of saying that if I were to do A, you would be permitted to do B. And it's a structured system that allows to evaluate where the one person is on a force level in comparison to where the other person is permitted to be, or is what they really term to be accepted to be at.
And is that then information that you both learned as a law enforcement officer and now teach?
Yes. It started, the first time you take a force course, one of the first topics they go over is the law and the force continuums, because without a thorough understanding of how and when you can do something, there's no need to move any farther into weapon systems and what you could utilize for that. So it's a really basic foundation that everything else comes from. And when you progress it through law enforcement, the options are quite different because there's so many things, what I call the bat belt. You know, a police officer has gear wrapped around them from pepper spray, tasers, impact weapons, firearms. The average person doesn't. So the continuum, even though it can be taken down and looked at through other perspectives, legal means and so forth for an individual, the essence of the continuum remains the same. It's just the availability of options changes.
And was this something, where does this training begin? Is this what you learn as a rookie, they call it, or a plebe, somebody in the academy? Or?
The training on force begins in the police academy. It's one of the what they call high liability courses that an officer must demonstrate proficiency in order to obtain and be able to test to obtain their law enforcement certification. So it is one of the key base building blocks that starts in the police academy and never ends. Law enforcement agencies everywhere are required to maintain an ongoing level of training on all the various weapon systems as well as communications, because that's also considered a component of use of force. Though all the things that an officer could utilize during their career, they have to maintain a level of proficiency, and that training never ends until the day that they walk out of their career.
And we were now talking in our timeline about your work at Riviera Beach. You've talked now about some of the certifications, if you would continue with those.
The other certifications that I went to, I was very into traffic. So in Riviera, I became basically the on-shift traffic unit. We had a small shift and we didn't have an active traffic unit. And I became involved with teaching DUI as well. So one of my other certifications, I became certified with DUI stops and things, and actually created a training program for the City of Riviera Beach that was approved through the State Attorney's Office on how to conduct a DUI investigation and how to properly document it throughout the entire DUI process.
How long were you with Riviera Beach?
Total, about 5 years.
And any other specialties or training focuses that you had with Riviera besides those that you've mentioned so far?
The only other things that really became certifications is while I was there, I did attend conferences geared toward defensive tactics. When I took my first instructor certification course in defensive tactics, I kind of fell in love with the topic and knew right then and there that that was something I wanted to do and specialize in for the rest of my career, if not longer. And I went and became an instructor for various techniques like vascular restraints. A lot of people call them chokeholds. They're not really chokeholds, but for layman terms, the police applied chokehold, for lack of better terms. Also in control points, which are the pressure points on the human body, I became a certified instructor with that. And I also became a certified instructor in, at the time it was called ink pen knife defenses. And what that was, the most common thing a police officer has on their person is an ink pen. And when confronted with an adversary, if you were utilizing your pen, it's a way to utilize the ink pen in defensive measures against somebody that may have a knife or other edged object, and you are not able to transition to your firearm. It was techniques to utilize that to defend yourself.
Now moving forward from Riviera Beach, first, any other certifications we haven't talked about yet during that first sort of chapter of your career?
No, that was pretty much it there.
And if I might, I'm going to have something more, if I might, Your Honor. Have you provided to us what we commonly know as a resume or a CV documenting some of this information?
Yes.
Would it be helpful to have this available to you as we go through your testimony?
It could. I mean, if there was something I didn't know, but I mean, it's my life, so I'm pretty
Okay.
clear on it. Unless you want specific date on an attendance of class, then I would probably have to look at my CV for that.
We have it marked. We'll keep it as that. If you can use your memory, that's fine as well. So let's move forward then from Riviera Beach. Where did you go after that?
The next agency I was with for a very brief period of time was the Jupiter Police Department, where I was assigned again to road patrol duties.
Okay. How long were you there?
That was just under a year. I was there just under a year, and during that time I had the opportunity also to take on a lead role as a defensive tactics instructor. When I was recruited by the city of Jupiter, I started and immediately began being presented with opportunities to bring the skills and things that I had learned from Riviera Beach to the Jupiter Police Department, and I began training with some of their other lead trainers on defensive tactics techniques and various things dealing with defensive tactics.
So in layman's terms then, defensive tactics is how somebody would defend themselves against somebody else.
It's fighting.
It's
In layman's
fighting.
terms, it's fighting.
And fighting in a way that minimizes injury to yourself?
Oh, absolutely. The reason it was initially termed defensive tactics is in law enforcement, pretty much when you utilize force, it's in response to another person's actions. So it became defensive in nature. Even though there are taught offensive techniques, the whole goal in law enforcement was you defended yourself, defended another person, you just didn't walk up and start a fight. That's where the term came from. But the reality of it is you're teaching people how to defend themselves through fighting techniques.
Why such a short period of time at Jupiter PD?
When I started there in Riviera, because it was a very active city, in Riviera Beach, I didn't spend any time on midnights. I actually was pretty much always on 3 to 11s, the afternoon, the evening shift where it was really, really busy. When I went to Jupiter, they had a seniority basis, and you had to be on midnights until you were there long enough that your seniority allowed you to leave that shift. Unfortunately for me, I learned while I was there is I have, for lack of better words, a condition that doesn't allow my body clock to change. So I couldn't adapt to midnights. I literally would sleep an hour and a half to 3 hours tops in a day, and it was really affecting me. So I went to the administration, told them about it. Normally, because you're on probation, they would just terminate you because you can't perform the job the way they want it done. I was blessed that they extended me the opportunity to move immediately to a 4 to 12 shift, which created a lot of strife in my career because there were a lot more senior people ahead of me that should have been given that position, but the administration elected to offer it to me. And because of the conflict that it created, it just seemed like a better idea that other options were presented to me, and I felt that it would be a good idea to follow them.
And just to clear up any concerns anyone may have, was the short duration of your time with Jupiter due to any disciplinary problems, any concerns, or any performance evaluation issues?
None whatsoever.
Then you went from Jupiter to where?
Martin County Sheriff's Office. I took a position as a drill instructor with the Juvenile Offender Training Center, their juvenile boot camp. It was under law enforcement special services, and it was a really unique opportunity to work with kids.
And what do you do during that part of your career?
The time that I was assigned to the Juvenile Offender Training Center, I started as a drill instructor in the boot camp, and because of my background and experience within a short period of time, I was asked to take over the training responsibilities for the program, where I helped develop training programs for ongoing training for new drill instructors and the current staff. Eventually, I was given the responsibility of being the supervisor of what they term the Sanctions Enforcement Unit, which is the equivalent of probation officers. When the young men come in through the system, by the time that they're there after about 6 months, they're released back into the community where they're monitored by deputies to ensure that they're transitioning, maintaining their curfew, and doing things like that. So it would be equated to as similar as being a probation officer for a juvenile offender. And then I was promoted to the rank of sergeant and ran that unit until I went back to road patrol and pursued other opportunities for me within the sheriff's office.
During the time you were with the Sheriff's Office, did you accomplish any other certifications or training in particular areas of law enforcement focus?
My focus, I had the opportunity to experience just about everything a police officer can experience while with Martin County. I was within their training unit. I was within their criminal investigations division as a detective. I was in the traffic unit, road patrol. I also served on the K-9 unit. And throughout my time, the entire process, I also was an ancillary instructor where I would go and take on and do training classes for a variety of topics, mostly dealing with force. I continued my education. I continued going to schools. I also became a master instructor. First became an instructor and then a master instructor with Taser International, which is the taser weapons, the stun guns. And then I started transitioning and teaching the instructor level courses for that. I also took over, when I was in training, I was designated the use of force specialist in the agency, where anytime there was a force event, the information was always forwarded to training. My job was to look at it, evaluate it, see if there were violations of either policy and procedure or training standards. And also I would try to take the experiences of the other deputies who were involved in various issues and see how we could turn them into training opportunities for the deputies that had never experienced it but may benefit from the experience. So throughout the remaining portion of my career, I dedicated most of my time to continuing my training and development of certifications in force-related topics. I got my firearms instructor certification. I also became a tactical shotgun instructor. I continued on and became an instructor trainer with pepper sprays. So I transitioned from where I had the instructor rating up to the instructor class where I could teach the instructor courses. And I continued. I also took on responsibility at the local academy, where I was at first started as an adjunct trainer for the Academy for Corrections and Law Enforcement, teaching defensive tactics. I was lucky enough that my teacher and mentor was stepping down and provided me with the opportunity to step up to what they call the lead instructor's position, which is the person who coordinates and organizes the Law Enforcement and Corrections Academy's defensive tactics programs. In the process, I also obtained my 2-year degree in criminal justice, which enabled me now to start teaching the instructor level classes for the college for like defensive tactics. So I became the instructor that taught the defensive tactics instructor's course.
You had mentioned a moment ago about this becoming a use of force specialist. Is this something that teaches what we talked about a moment before, which was this continuum of force and how and when to use force in a law enforcement situation?
Yes, as the designated use of force specialist for the agency, my job was to develop use of force training. I worked with fantastic instructors for firearms, defensive tactics. I was given the privilege of coordinating a lot of the training that took place, especially if it fell to force of any type, whether it was handcuffing, because I took it upon myself also to go and get schools to become a handcuffing instructor, not just the ones that come from defensive tactics, but other disciplines and other organizations that offer that type of training, because I was always trying to find a better way to teach our personnel and other people how to stay safe and utilize the weapon systems. I, throughout my career, continued and went back we have regional trainings where I would go to the CJSTC-sponsored annual certification courses for high liability instructors and continue acquiring additional instructor certifications that tapped onto and added to already existing instructor certifications like tactical handgun and shotgun. I also went to NRA courses where I started to attend classes to get NRA certifications for firearms training, and I became a state licensed firearms instructor, so that I started teaching armed security courses. I had already been teaching unarmed security training for security officers, but by obtaining the state licensed firearms instructor certification, it enabled me to teach the firearms aspects of security. And I just continued developing training that was eventually geared toward and took over where I was presenting some of the civilian training for the sheriff's office. From one of the most important jobs for law enforcement or any company is the fact of communication. So I took on the responsibility of teaching a program known as verbal judo, which is tactical communication, how to communicate with somebody in a way that's not aggressive. So I also added that to my responsibilities as the force specialist. And I continued to develop the training programs for the sheriff's office. When I was offered other opportunities like going to K-9 and things like that, I worked very closely with the lieutenant of our training unit in continuing to develop training for the agency as a whole.
Not to focus on probably the least significant of the certifications you just discussed, but there are actually proper ways to handcuff people? And
yes, there are techniques, because you have to be... Handcuffing somebody is putting restraints on them. You have concerns about that because if you place them on too tightly, it can cause injury to someone. Also, if you don't properly train the individual on how to use restraints, there's what I call the good side and bad side to handcuffs. The good side is the side that actually moves. So when you make contact with a person, it'll ratchet around and actually move. If you use the bad side, make contact, you can cause injury because it's basically two pieces of steel that you're slamming into a wrist, so it can cause injury. So yeah, there are techniques that you should continuously revisit, even as something as small as handcuffing.
okay. You mentioned that as a use of force expert, you would sometimes use opportunities or situations as training exercises. It sounds like good speak for when another officer doesn't do something right, you help retrain them. Was that part of what you did?
Yes and no. I mean, it's not just when they don't do something right, it's also when they do something correctly. When you get a force event in, I get handed paperwork that says, basically, here's what happened. I took it upon myself. I would speak with the officers involved. I would speak with supervisors involved. If we determined something was wrong, then obviously we needed to re-educate that officer on how to do their job properly. But we also use that as an opportunity to make sure everybody else remembers this is the way to do it. But just as important, when an officer was involved in a situation that was just unique, that no one else up to that point had ever been involved in, we take it, we look at it at its face value, and then we try to create a training scenario that we would be able to put other deputies or officers through a similar controlled event so they gain the experience. So it's not just when they do it wrong, it's also when they're doing it right, and we're adapting it to training for the agency as a whole.
And as you then continued your experience as Martin County Sheriff, did you get or continue a focus on those use of force events where you became the go-to person for those?
I was lucky enough that throughout my career, and because of my training background and experience, the agency, the state attorney's office, when there were force events that took place, shootings and things like that, I was the person that I was given the opportunity to evaluate, review, and provide an opinion on it. I also have been contacted by agencies surrounding us as well as across the United States because I've taught at or been with other training programs and have met a lot of people, and I've had the opportunity when they've had something unique or they're developing a policy for the first time, or for example like with the taser weapons when they were brand new, I would get phone calls about making recommendations on how their policy and procedure should be written so that it conforms both with what the manufacturer requires for training programs, but also what meets a lawful need given the use of the weapon system. So I had the opportunity to be the person that went other agencies and individuals came to, as well as testified at grand juries about officer-involved shootings. I've testified or I've spoken to other agencies and counseled other personnel on proper documentation as well as techniques for use of force.
Other certifications that we haven't talked about that you've accomplished through your time with Martin County, we've talked about some of the use of force and the particular weapon systems, and you talked about defensive tactics and NRA. Any other particular areas of training or focus that you had during your time with Martin County?
I'm kind of unique because every time I take on a position, I try to find an instructor's course for it because I was truly in the mindset that if you learn to teach it, you can perform it a little bit better. For example, when I became a canine handler, I was very vested into the position, and then I became a canine team instructor. Each and every weapon system that we had, from a Kubaton to an impact weapon, as far a Kubaton being those little key ring things that you can use for, they're like maybe 6 inches long plastic that you'll see on some people's key rings. Those are little impact weapons, little batons, up through including full-length batons, knife defenses, handguns, long guns. I participated in the training of our agency for rifles. Everything, if it's a weapon system, I had the opportunity to provide training with it. And if it was a weapon system that I was dedicated to, like vascular restraints, or if it was impact, OC, taser, firearm, I went and became an instructor and eventually created, I currently have 4 courses that I've created myself that I travel and teach as an instructor of the instructors.
And aside from that specific to law enforcement, do you have any training or expertise in general physical combat, fighting, or areas that aren't specifically law enforcement but still assist you in a presentation regarding use of force?
I started martial arts training when I was about 13 years old, and I became a semi-pro kickboxer. I was very lucky. I got to participate in the 80s in the ISK super fights and things. Actually, it was right here in Orlando. It was my first super fight that I was able to participate in. So I've always had an interest and involvement in physical combat. I grew up with 2 older brothers, so I got beat up a lot by my older brothers, and it was just seemed like a reasonable thing to do for me to try to bring in that personal experience. So in the process of my own personal experiences with fighting, martial arts, kickboxing, training, I was actually training with Chris Anderson and Rico Brockington, who were at the time in the late 80s, they were both championship fighters, boxers. And I had the opportunity to train with them and to learn from them when I was attending my kickboxing schools. And I just continued on. Currently, I'm involved with a martial arts organization, and I've been given the privilege of developing and working with them in developing firearms related to martial arts, where it's a component, because a lot of people think of the samurai with the swords, which is very accurate, but believe it or not, toward the end of the samurai's era, they actually were using firearms. And it's a lot of things about the history of fighting that people don't know. And I'm blessed to work with a gentleman by the name of Dennis Ritchie that runs an organization dedicated to the traditional aspects, and he's trying to bring in all these components so that people can learn safety through martial arts training, the peace, the mind, the essence of the spirit, and take it all the way through even the modern day weapon systems that people utilize today. And I've been blessed with the opportunity to participate with that.
Ever take the opportunity to even the score with your brothers?
I did, but it was very young, and I lost. And I got blessed enough that as I became a police officer, my brother's also a retired police officer, but through our transitions in my schooling, he started to realize, I think, that it was better just to leave me alone. So at some point, the tables turned. I could just, I like to just think that he knew better. I don't know that he did, but I like to think that he did.
That's good. And during all this time with Martin County, you completed your law enforcement career with Martin County, correct?
Yes, I retired in April of 2011.
During the last few years of your tenure with Martin County, can you advise the jury sort of even more what your focus was on assisting the county, the sheriff's office, in dealing with their use of force events?
In the latter portions of my career, I became involved with the sheriff's office for, just like I already said, all the force training. I maintained that all the way to the very last day. Matter of fact, even after retiring, I was offered the opportunity with Sheriff Crowder to continue training with the agency, and I had accepted that opportunity to do so. And during that time, I had permission from the Sheriff's Office to start my training company, where I started doing law enforcement training and eventually individual, or what we refer to as civilian training.
And during that time, particularly the last few years with Martin County, did that include opportunities for you to review use of force events and to either testify in someone's behalf or to deal with the administrative side of a use of force event?
Because of the area, we're blessed that we don't have a lot over the careers of shootings, but we have had our fair share. Toward the end of my tenure with the Sheriff's Office, as a use of force specialist, I was approached by the state to testify, to review and provide an opinion for a grand jury on use of force events involving police-involved shootings that ended up in the death of the subject being shot. I was also brought in by our agency at the Martin County Sheriff's Office when we had organizational involved shootings, that there were times where I was brought into administrative meetings to meet with the attorneys group to do an evaluation of the use of force to determine whether or not I had considered that event at that time to be reasonable or not, and to provide input as to why it was or was not. So I kind of helped the attorneys group for the Sheriff's Office representing them in forming an idea as to what actually took place, and I was also given the opportunity for the state to do the same thing for grand juries.
And if you would, just tell us a little bit more about the experience that you've had with your presentation to grand juries. What would you take on? What was your role, and what would you present? Obviously, we know that any particular testimony in front of a grand jury in and of itself would be confidential. So I'm not going to ask for specifics, but generally or generically, what would you do?
Essentially what happens with a grand jury is I would be given all of the evidence. I'd be given a copy of all the written reports, any radio transmission CDs of any videos, photographs, crime scene photos, everything. I would be given the opportunity to review all of the evidence, because as the use of force expert, your job is to evaluate it from every perspective possible. You can't just walk into an event, look at it, and say, okay, that's how it worked, because nothing works that way. Every single person sees things differently. So I would get all of the evidence. I would be given an opportunity to review all of the evidence, formulate opinions based on my background, training, and experience as to how I thought it went, provide an opinion as to whether I thought whatever was done was either considered to be objectively reasonable or was considered not to be objectively reasonable. Then what would happen is at a grand jury they would call all the witnesses in, and I would come in and the state would ask for my opinion, and I provided to the grand jury of what my opinion was based on my background, training, and experience as to whether I thought what A, B, and C was it objectively reasonable given the facts and circumstances known to me with all the evidence, or was it unreasonable?
On how many occasions did you have an opportunity to present such testimony to a grand jury?
I believe it was 6 different times.
May I approach the witness for a moment, Your Honor?
You may.
To review with you what's marked as our Exhibit RRF. You can identify that.
That's my curriculum vitae.
That was something that you prepared both for other cases you've been involved in and for today.
Yes.
We'll present evidence if I might, Your Honor. I think there's no objection.
No objection?
Correct.
Okay, Defense Exhibit RR will come into evidence as Defense Exhibit 24.
And regarding your most recent testimony, concerning your testimony with the grand jury, we've had a discussion about what you will and will not testify to here today, correct?
Yes.
As far as your focus of the Zimmerman case. So let me ask you in that regard, how you and I first got together or how you became a witness in this case.
I actually reached out to Mr. O'Mara when I saw the case unfolding, obviously like everyone else in the media. I had a unique interest in it because there was so much information being flooded through the media. I didn't know exactly what had happened, obviously, as no one does. And I reached out to him because I thought I had a unique perspective as to coming to a realistic conclusion on things. being
Okay.
able to proffer and look at things and just render my background training and experience to him to see if it helped. My experience has been, I wanted to ensure, and the most common question is, I reach out to a defense attorney as a police officer or a former police officer, and the truth is, there are a lot of people that can do what I do. There's plenty of experts available. And I reached out to Mr. O'Mara because it was my belief that if I reviewed the material and felt that I could be of no assistance, I would not do anything to hinder the progression for anybody in this case whatsoever. But if it was something that I felt that I could help with, I went to the one party that if it was an opportunity to be of assistance, I knew that I would be able to do so. So I reached out to him and to see if he had interest in using my services.
Okay. And that then began the process where you and I began working together on this case?
Yes.
And if you would, just advise the jury, generally, and if appropriate, but more specifically, what you would want available to you for review in a case like this, and then what you got in this particular case.
What I request is just like with the state and the grand juries, everything that I can. As a use of force expert, I have to look at it from as many perspectives as possible, because everybody's perspective is different. You have to take into consideration what their upbringing was, what their background was, where they lived, what their personal life experiences were and currently are. So my request is to obtain as much information as possible, get any witness statements that I can get, any photographs that I can get, all the evidence that's available, so that I can help see a complete picture and not just a picture that'll be guided from one direction or another. An expert's job is merely to look at everything and evaluate it in the totality of the circumstances, not skewed by one person's opinion or another person's opinion.
And in this case, then, what information did you request and what information was given?
Pretty much everything that I requested was provided. I can't think of anything that wasn't. I requested to be able to review the 911 calls. I requested to be able to review the reports from law enforcement, from the medical examiner's office, anything that was documented or written down, so that I could get an insight from not just the witnesses that provided statements, whether it be orally or in writing, but also from the investigators that were conducting it, so I could also look at the questions that were being asked to see. Sometimes you can think of a question you don't know, but as you go through a different investigator, they thought of the question, so seeing all the investigators' reports was very important. TV interview. I had either not seen it in the materials or something, and when Mr. Guy asked me about it, I wasn't aware of it, but since then I have viewed it.
Are we speaking now about the Sean Hannity interview?
Yes, sir.
For your purposes, understand that that's in evidence now. The jury has reviewed that. So as you incorporate that into your testimony, be aware that they know what it is you're talking about.
Okay.
Did you get enough information in this case from which you could review the available information to focus your opinion regarding the events that happened that night?
Yes.
In the overall scheme of cases and comparing the information available to you in this case to others that you reviewed, is this less than you normally review, average, or more than you normally get a chance to review?
I would say this is average for the significance of this issue. I think that there was a lot of material, but it's on average, when you deal with an event of any similar nature, you're going to get a lot of data.
We've had other experts testify, and within that context, they narrow their focus to their area of expertise, and I would ask you to do the same. So if you could sort of lay the foundation for the jury, when you're looking through all of this information, all of the witness statements, all of the pictures, all of whatever it is, what filter are you using to focus the information that's relevant for you and your opinion?
Well, I focus everything based on background, training, experience, knowledge of, in individual or civilian realm, knowledge of the law, and all of the information. I focus it based on the totality of the circumstances known to me, and I bring in my background, training, and experience, both for law enforcement and individual. Because one of the things we didn't talk about for my background is my training company is, I now primarily do individual type training, firearms training, self-defense classes for children, adults, and seniors. So I take all of that background training and experience, and that's what I use to filter out the information. And I couple it, obviously, with over 20 years of law enforcement experience in evaluating information that's been presented and understanding how things may be affected by other people.
And was that then done in this case?
Absolutely.
So what information that you had available to you assisted, well, let me back up. Was your focus of your investigation of this case, in your opinion, based upon the event specifically surrounding the intersection of Mr. Zimmerman and Mr. Martin that night?
That was the primary focus area.
And the altercation that ensued and the eventual shooting?
Correct.
Okay. So if you would then, with that, I guess, as your filter, walk the jury through what information you looked at and then found relevant to assist you in formulating your opinions.
Well, the first thing that I utilize is the initial statements, the initial calls that come in. It's really important to establish a timeline for events. A timeline is very important because it helps you understand and compartmentalize information to the best of your ability, because as with any issue, perspectives are skewed. So what some people may see or hear another person may not doesn't mean that they didn't witness something or that they didn't know something. It just may not be from the same perspective as another witness. So the first thing that I looked at and listened to were the 911 calls that came in. Then I added to that the initial interviews of the key witnesses. I use the word key witnesses, the people with the most information that saw or heard the most that could be relied upon. And I used...
I'm sorry.
Yes.
Just so you're aware, I know that in depositions and prior conversations with you and I and the state and you, the identity of certain witnesses was kept confidential. We were using witness names, and I think I said half a dozen times to you not to ever mention the witnesses by name. That restriction has been relaxed. Those witnesses' names are now available to the jury. So to the extent, I withdraw my request of you earlier.
Okay.
So to the extent that it is relevant for you to identify them by name, you may have trained yourself to just use numbers, that's okay as well, but to the extent that you can utilize the names, it would be helpful for the jury to know particularly which witnesses you talked about or read about.
Okay, that does help a little bit. I reviewed all of them, and forgive me if I don't pronounce all their names correctly, because some of the names are very difficult. Statements from Ms. Lauer, Mr. Good, the Bahadors. I listened to every audio recording from the 911 calls that came in, as well as from the witnesses. And I tried to filter through what each witness said and compare it to where on a timeline it could fall. You know, for example, just as a brief example, if somebody said that their attention was called to the event because they heard screaming, well, that tells me within the timeline that certain things had already taken place because when the screaming started. So you have to look at it and try the best you can to filter in the information. And then you take into consideration witnesses that actually, like Mr. Good, who actually stepped out and had a time where he interacted from a distance with the participants. I used all of that information to begin forming my opinions and to focus in my energies on evaluating what I thought may have taken place.
I didn't mean to interrupt you.
No, that's fine.
As to the witnesses that you viewed, the statements and the information they presented to you, based upon your training and experience, 20 years worth or more as law enforcement, how do you view witness statements and whether or not you can guarantee accuracy or not?
I look at it, it's very fluid. Accuracy is based on perspective. I'm a movie fanatic, so there was this movie by Dennis Quaid for Vantage Point, and it showed one singular event from like 8 different perspectives. That's the reality of most encounter every single person has, is we all have our vantage point. We all have our perspective. So as I begin to listen to the statements that are being made, when I said I listened to the 911 calls and then the initial interviews, one of the best things about the initial interviews as a person evaluating an event is the fact that you're usually getting the most raw information. In other words, that's the most immediate access information from their brain right there without any other stimulus or influence of any type. One of the first things that we do as investigators is separate witnesses, because everybody that talks, I may say that, if I can use Mr. O'Meara, is wearing a pink shirt, and you only see it for a quick second, and you thought it was like an orange shirt, and I'm wrong and you're right. If I'm strong enough in my conviction, you may sway to my perception. So when I look at it and I listen to and I evaluate what was said, I really try to go back to the original statements that were made before there could have been any other outside variable or influence, because those usually are the most raw. They may not always be the most complete, but they're the essential elements of what a person witnesses, because they're usually the ones that strike the deepest inside a person's mind. So when I begin to review information, I listen to the calls and I go to that initial interview. If they have a subsequent interview, which in these cases there were other interviews at other times, you can see things change a little bit. And one of the most important things is to remember, again, perspective. I have a thing that I call the hot pot theory. Hot pot theory. The idea behind it is about perspective. And when I teach classes, I explain that if I took a pot and I placed it in the freezer and it got ice cold, and I took it out and I placed it on your stove, and you came in and I asked you to pick up the pot and move it for me, the moment you make contact with the pot and you feel that complete change in temperature, you're instinctually letting go and moving away. And then most people, not all, but most people will test the water to see, because their brain took into account the environment, the event, what they perceive. What is a pot when it's on a stove usually? It's very hot. When they touch it and feel that sudden change in temperature, their perception was, even though it wasn't, it was very hot because of all the external influences. So when I look at and evaluate statements being given, what I try to do is put myself into that person's shoes the first time they spoke. What did they see? What did they hear? What can they remember? Before they have any of the other influences. Because remember, even under that high-stress event, they're still having influences, whether it's dark, the lighting, raining, whatever the case is. There's environmental influences. If they just had a discussion with a loved one that didn't go well, that's going to influence their perceptions. So you try to look at it from their perspective and merge, if you will, their perspective with the perspective of another, and the perspective of another, coupled with physical evidence and things like that, until you arrive at what you deem to be a logical conclusion.
So in your experience, then, if you run into a situation where there are conflicting statements about the same event, is that an understandable occurrence to you, or is that evidence deceit, or how do you resolve that?
Conflicting statements are normal. They're also very normal from the people involved in the event. Something to remember about high-stress events. A high-stress event can be something like somebody driving down the road and a car coming across their lane when they didn't expect it. That was a very stressful event. Certain things happen inside the human body. I do training classes for the psychological and physiological aspects and effects of stress on a person during combat. People that witness horrendous events go through a similar emotional response. So you have to look at it and understand that there are going to be deviations in statements because of perspective, stress. Some people don't want to acknowledge some things because there are some people that want, honestly, to live in a bubble, and their perspective is based on they don't want to accept that certain things happen. So when I look at it and I get statements, if they're conflicting, you look at the essence of the statements and you try not to get hung up, if you will, on small changes. Now, if their entire statement changes, that creates a completely different animal. But when you talk about a person who has just a slight deviation, you look at it in the context in which it was presented and see if maybe there's been another variable that caused that deviation. As far as a deviation from witness to witness immediately following an event, again, that's just based on perspective. There's always going to be those variances.
So we had an opportunity to review, as you mentioned, the witness statements in this event. I focus you on Ms. Sudaiker's event. You have an opportunity to see that or review that statement?
Mr. Diker?
Ms. Sudaiker,
Oh, Sudaika.
the woman who thought that she heard maybe three
No,
shots.
I'm sorry. I need to interpose an objection as to improper and asking this witness to comment on another witness.
I'm not seeking for impeachment, Your Honor. I'm actually seeking to explain.
Well, I'll listen to your next question then.
Okay. You read Ms. Sudaiker's statement where she suggested that she thought she heard 3 shots?
Yes.
Okay. Did that give you any cause for concern, or is that just a perception issue that you just fit into the rest of your evaluation?
The same objection as his commenting on a witness. The testimony of another witness.
My response, but I want to speak the
Okay, well then
objection.
approach.
talking a moment ago about your review of Ms. Sudiker's statement and the fact that she heard sort of a pop, pop, pop. Did that cause you any concern, or did that just sort of fit into the idea of what you mentioned a moment ago about people in certain situations, particularly if they're stressful, might interpret things in a certain way?
As far as raising concern, no, it didn't raise concern. You know, as just the first thing that comes to mind when somebody talking about multiple sounds, especially with gunshots, in enclosed areas or areas that are not wide open, sound travels, reverberates. So it's not uncommon for somebody to hear one thing, and it sounds like many because of the fact that the sound itself is bouncing off of either buildings or alcoves or what have you. Also, every human being, like I said before, when we talk about distortion, we have what we call perceptual distortions, and high-stress events change the manner in which we see things. You know, and I always use the law enforcement experiences because there are people who think they see one thing, and then later on they second-guess themselves. They actually saw it, or maybe they saw a portion of it, but their perceptual distortion, because of the high-stress event, it alters the manner in which they interpret the information that they're receiving. That's a natural human response for everything. You know, when you talk about any kind of dynamic high-stress event, people will experience perceptual distortions or memory issues, for lack, you know, that's what a lot of people call me, well, it's a memory issue. Well, it's the way they perceived it, and sometimes it's just that stress event repeats for them, and they're trying to make the best sense of it, the best that they can.
So we were then talking about the other information and how you sort of filtered into the event that was a particular focus of yours, and that is the altercation itself. So if you would just continue through that with the jury as to the information you looked at, most particularly that which you perceive to be relevant for you in determining or accomplishing an opinion regarding the altercation.
The information regarding the specific altercation was Mr. Good's statement, coupled with the 911 calls, Ms. Lauer specifically, which really had, from what I've reviewed, the most clear, for lack of better words, information for the background involved in what was taking place in the event, coupled with the photographs of Mr. Zimmerman's injuries. I utilized those calls, those statements, those injuries, and then you have to be able to match things up. You try to look at it and bring it into perspective and say, does this lead to this? Do these make sense? Are they within the realm of one another? You know, when you talk about somebody involved in a physical altercation, you know, whether it's, I have to evaluate it from perspectives of what, if I was in Mr. Good's shoes and I saw what I saw, would it make sense? If I heard one of the other statements that, again, coincided, I'm trying to remember the name of the lady, but she indicated even in her interview with law enforcement that she saw flailing arms. Those could coincide with what was being seen by Mr. Good.
Objection, Your Honor. Again, Your Honor, he's commenting on the testimony of previous witnesses, invading the province of the jury.
I think he just utilized that as, he didn't comment. Well, I don't want to, I'll move him on, Your Honor.
Thank you very much.
Explain then for the jury those particular, what elements in this event were of relevance to you. And I don't want to lead you through it, but environmental events, relative size events, the elements that you would look at in order to identify areas of focus for you in determining your thoughts on the altercation.
Well, the elements have to focus into perception, the environment, lighting conditions, the physical altercations, the injuries that were being, that are photographed as being sustained by Mr. Zimmerman. When I look at a dynamic event and you have to evaluate it from A to Z, you have to look at, once the event began, if it continued and you had an unrelenting attack coupled with injuries and the perception of the individual sustaining the injuries, my my interpretation is taking into account all the witness statements, forming the beginnings of the actual physical interactions, and using them to show that if you are and consider an individual who is on their back, somebody in a mount position, striking, throwing blows, pushing, whatever the case might be, driving the person down, the person underneath, what would their perception be at that time? And I have to look at it and say, my perception, if I was in those shoes at that time, what would the perception be given the dark environment, the wet environment, the efforts to gain assistance, the continual attack? And then I have to lead there and to figure out what would be a response.
So you've identified a couple of environmental events that I want to focus on for a moment. What information did you have from the discovery provided as to the actual environmental status?
Well, lighting was poor at best. It was very dark out there. I mean, things had to be illuminated even for the photographs that were being taken that night. It was wet. So we have dark lighting conditions, and for lack of better terms, an otherwise isolated area, dark behind buildings. Okay, wet conditions, which, wet conditions you got rain, you've got ground water, slippery environment, and then you've got, like I already said, the isolation of the individuals in the dark. Those are all variables that have to come into play because they play on the human mind during an event.
One point I want to make concerning, well, my understanding is that you utilized Mr. Zimmerman's statements that he was struck first as you moved forward with your opinion, correct?
Yes, that was his statements, and that's what I used. He was struck first, yes.
And in addition to his statement itself, was there any other evidence that you're aware of in that regard?
Well, the initial statement, as far as striking taking place...
Judge, again, I'm going to object as to the basis. He's trying to testify now to bolster...
Okay, what's your legal objection?
It's an improper question because it's bolstering the defendant's statement.
Okay, sustained. Rephrase your question.
Certainly. Did you look at any of the photographs of Mr. Zimmerman in order to assist you in making the opinion or in documenting in your mind that he was struck?
Without question, when reviewing the photographs of Mr. Zimmerman, taking into consideration the statements and the totality of all the information I reviewed, when I looked at the photographs, they were consistent with the information that was provided.
Did you also look at the location where one of the exhibits was found near the T intersection?
Yes. There were a variety of photographs, but there was a small flashlight found near the T intersection.
Did you identify through the evidence presented that turned out to be Mr. Zimmerman's keychain and flashlight?
Yes.
Did that assist you in determining potentially where, or did it support where the altercation began?
Same objection, Your Honor.
That's it's his opinion, Your Honor. That's what I was asking for.
Maybe he's asking, does it support an account?
I'll ask him a different way.
Please, thank you.
Does in your opinion, does finding Mrs. Zimmerman's flashlight at the location near the T intersection assist you in determining where the altercation may have taken place?
Of course, it's an indicator that when you look at the totality of a combat event, something was a catalyst to cause him immediately to drop that item in that location.
So we were talking about that piece of evidence and other environmental situations. Did you have an opportunity to view, for example, the composite I just showed you showing the sidewalk going down the center of this area that you just spoke about?
Yes.
And did you see pictures in that regard as well?
Yes.
Did you have an opportunity to review pictures regarding injuries to Mrs. Zimmerman's head?
I did.
Did that assist you in forming your opinion concerning how those injuries may have been inflicted?
Absolutely.
And what is that?
Based on the injuries that I saw depicted in the photographs, they are consistent with a fight, a physical fist fight, if you will. There was it did not appear by the injuries that there was any actual weapon used. The injuries that I saw, based on my training background and experience, were consistent with that of a fist fight.
And the injuries on the back of the head, were they consistent with the head being struck on anything besides a fist?
The injuries on
Object to that is outside his area of expertise.
I would sustain that objection.
Okay. In looking at the pictures then of the pathway and the sidewalk and the placement of the bodies, the two individuals, by Mr. Good, did that assist you at all in determining where that altercation ended up?
Absolutely. It was very clear.
And where did it end up?
Just outside. It ended up on the grass. It was on the concrete and it slid down. It was on the grass. And if you're asking where, I believe it's outside Mr. Good's townhome.
In your consideration of use of force events, do you consider the relative size and physical abilities of the two individuals or the number of individuals?
Absolutely. Like I said earlier, when we look at a force continuum, one of the first things you evaluate is what we would call in this case individual factors: age, size, gender, apparent physical abilities. You can also take into consideration special circumstances. You look at overall, when you look, from my perspective, we look at background, training, and experience of people as well, not just what you get at face value, but we try to go a little bit deeper to gain a better understanding of physical abilities, because we can't compare Joe Blow and John Blow because they may have completely different background, training, and experiences to come out to a different result.
In this case, did you have information made available to you about Mr. Zimmerman?
Yes.
And if you would explain to the jury what information you reviewed to assist you in your analysis of his physical abilities or interaction abilities?
I spoke directly with I actually spoke with Mr. Zimmerman once, and I spoke with Adam Pollock, I believe the name, I believe it was his gym owner, the personal trainer, about him, and I was inquiring as to what his background, training, and experience was, because that becomes a very important variable for me when reviewing the use of force. If I was dealing with Chuck Norris, I would expect a completely different response to any kind of physical altercation than I would if I was dealing with Pee Wee Herman. So I always do the best that I can to try to find any resource material or people that can provide me with a background on an individual.
And I presume that the two of you can sort of speak the same language, having similar backgrounds in fight training and kickboxing, whatever else it is?
Yes.
Okay. Within that context, then, what information were you able to glean concerning Mrs. Zimmerman's physical prowess or abilities?
Without sounding offensive, he really didn't have any. Mr. Zimmerman was described as being a very nice person, but not the fighter. The concept is we deal with, for example, and I'll just use a law enforcement reference, we deal with the warrior mindset. The concept that somebody is dedicated to the very end, that they dedicate their life and abilities and their training, and some people are naturally born athletes. Some can learn athletic events, but some people are just naturally born athletes. My interactions with Mr., I believe it was Pollock, the gym owner, he indicated that Mr. Zimmerman's background, his training was limited to the best of his knowledge to that period of time that he was at the gym. He did accomplish great things with his weight loss, but his physical ability, I spoke specifically about the boxing class that I had been told that he had taken, and I learned that the classes were more of a class of convenience, and that he never surpassed shadow boxing or working a heavy bag. Grappling, on the other hand, he went from a bag and he was working with a partner. But it's very important to understand the difference between the two concepts, because in grappling, you have the opportunity to what we call tap out. You can say, I quit, I give up, if something hurts too much. In boxing, when you enter a ring with another person, you find out entered into too much, more than you can handle when you've been punched and injured already. And according to what I learned about Mr. Zimmerman is he didn't have the physical prowess to go into boxing another person. Shadow boxing and working the heavy bag were the safest parts for him. He wasn't at a skill level that permitted him to physically interact with another boxer.
Any further information that you became aware of regarding Mr. Zimmerman's physical abilities besides what you've just testified to?
No, sir, just what the gym owner had provided me with, his background from his experience with Mr. Zimmerman.
Okay. As to Mr. Martin, I don't want you to discuss any anecdotal information that you may have heard about, but just focusing on his physical size, age, whatnot, and to the extent that you believe that that was relevant in comparing the physical abilities, if you would give the jury your thoughts on that.
Well, looking at the physique, the overall size of a person is more telling about an individual than age. So in my review of it, there was nothing that indicated to me that Mr. Martin wasn't physically capable. When I looked at his size and weight, they were comparable to and I saw the photos of him. He seemed to be overall in good physical health and physically fit comparatively to Mr. Zimmerman, who was in the process of losing weight. There's no question he had gained great value in weight loss, but he was not, from what I could see and understood from his physical descriptions, to be of physical prowess or physically fit. And we have to focus, and I even, in the reviewing the documentation provided, the EMT reports and things like that, photos don't tell you everything. That's the one thing, is a picture can't tell you everything. So I rely on other sources of information, and I read in the discovery that the fire paramedic estimated Mr. Martin to be 20s. So, his physical, again, that's another resource that I use. I interpret a photograph, but I'm not standing there right next to him. So I use that also as a reference material to get a generalized idea of the physique of another person when using it in comparison to the other party.
And what are your thoughts then on the comparison between the two individuals as far as their physical abilities?
Comparing what I know of, to the best of my knowledge, for each individual, Mr. Martin was a physically active and capable person. Mr. Zimmerman is an individual who is, by no stretch of the imagination, an athlete, and that his physical, I believe, it's my opinion, that the physical abilities, he would find himself lacking when compared to Mr. Martin.
Moving on then to the actual event itself and the information that you had available to you as to how it unfolded. We've talked or begun with a conversation about at least Mr. Zimmerman's perspective and the other evidence that you talked about as far as where it started. Did you give any consideration to the length of the altercation?
Of course I did. I mean, when you talk about any kind of dynamic combat event, when I say that, I'm talking about just in layman's terms, a fight. We have a golden rule that if you have not successfully completed the fight, if you have not won the fight in 30 seconds, change tactics, because the tactics you're using aren't working. The average person's adrenaline dump, the endorphins that get pumped in under stress, within 30 seconds you've depleted just about everything you have as far as giving 100% of your physical ability. And if you haven't been able to successfully win the event in the first 30 seconds, you need to change tactics. The reason we talk about that, that's both in law enforcement and individual, the civilian realms, is when you find yourself in a physical altercation, you only have so much gas in the tank. And you can only do so much based on your background training and experience. So the longer the fight takes place, the more fatigued you become, the more potential there is for injury, everything begins to unravel. I don't ever say that you've lost. All we say is you have to change tactics. You have to find another thing, because if you haven't physically been able to succeed in the first 30 seconds, from that point forward, you are now diminishing on return physically. In this particular case, just going off, the timeline of the 911 call, given the period of time, and I personally have sat there and timed it myself, where it's about 40 seconds of time. That's a very long time to be involved in any kind of physical altercation. And that most certainly plays into the decision-making of any individual involved.
Did the event of someone screaming for help, screaming during the event, did that impact at all on you in how you perceived the altercation?
Listening to the sounds as it unfolded, it is clear that the what I would call the cries, the shrieks for help, indicated a high level of stress, a high level of fear. That's what I interpreted those screams and those sounds to mean.
And how about the length of them, how long they lasted?
From my perspective, it lasted forever. When you talk 40 seconds, the average person doesn't truly conceptualize what 40 seconds is. As a taser weapon instructor, we give 5-second applications of that weapon system to our personnel. And without fail, during that time, at the end of that 5 seconds, the officer or deputy that's had to endure it will look at you and go, "You held it for longer. There's no way that was just 5 seconds." Because we don't truly have the concept of what 5 seconds is. Imagine what 8 times that is, 40 seconds. 40 seconds is an eternity when you're involved in any kind of physical conflict.
At some point, from the information that Mr. Zimmerman discharged his firearm.
Yes.
When you look at a discharge of a firearm event, is this then in the context of what you have done in your training and experience you've talked to us about with officer-involved shootings? Is this something that you'd look at and focus on as to what happens that leads up to the discharge of a firearm and what happens afterwards?
Yes.
Okay. We've now sort of talked about what leads up to it, because I'm now bringing you to the point in time where the firearm is discharged. Was the discharge of the firearm itself, the way it was discharged or the number, instructive at all to you?
Well, based on the information that I reviewed in the discovery, I concluded that I'm a little unclear on the question. Can you clarify it?
Sure, let me refocus the question. Is it your understanding that Mr. Zimmerman shot his firearm once?
Yes, one time.
Is that unusual to, in effect, stop at one, or in your experience in matters of officer-involved shootings or other shootings that you've looked at, can you offer any insight to the jury regarding that?
Judge, I object to that as improper, irrelevant as to any other law enforcement officer in the discharging of their weapon or any other person for that.
Okay, that's a speaking objection. Your objection is?
Relevant.
I have to sustain on that one.
Okay. Is anything in the discharge of his firearm, from your view of the event, evidence to you that Mrs. Zimmerman acted in some additional form or fashion of ill will, spite, or hatred, realizing, of course, that the discharge of a firearm at somebody is an event that can cause death?
Judge, I'm going to object as improper based on our limiting motion.
Okay, if you'll please approach.
I asked you a question, I want to rephrase it a little bit to focus your answer. I asked you whether or not the firing of a single shot evidenced certain ill will or hatred. I want to clarify that a little bit and then just ask you to answer it yes or no, just so we get to that point, but I don't want you to expound too much on that, okay? The modification of my question is this. Looking at the fact that the gun was fired at close range, did you know the premise question you're on, did you know the gun, did you know how far away approximately the gun was from Mr. Martin when it was fired?
Yes.
And what did you know that to be approximately?
If I remember reading correctly, it was within 6 inches.
Okay. Realizing that as a premise question, that it was a close range shot and that it was shot one time, did that evidence to you, based upon your training and experience, anything that would suggest ill will, spite, or hatred towards Mr. Martin by Mr. Zimmerman?
No.
Okay. Now, let's go to the point after the shot is fired. In your background and training and experience of people involved in shootings, how are, as an example, how are law enforcement shootings handled as far as the interview of the person who shot?
Well, generally speaking, with law enforcement involved shootings, it's they do a
Objection, Your Honor. I'm going to object to relevance.
I can respond, I just don't want to speak.
Well, I think if it's to put it into context, I'll
Yes.
give you some leeway.
Thank you. And just so we're clear as to that, the majority of your experience and training is because of your law enforcement background. You deal with law enforcement events, correct?
yes.
Have you had experience where you handled non-law enforcement shooting events?
Yes.
Okay. So do you have an experience level that covers both law enforcement and non-law enforcement shootings?
Yes.
Is the majority of yours, however, in law enforcement shootings,
Yes.
by nature of you being a cop?
And yes, and just retired a couple of years ago.
Okay. With realizing that, using the complete broad base of your experience, including law enforcement shootings and non-law enforcement shootings, what are the concerns that exist with interviewing a person who's been involved in the event of a shooting?
Memory issues. Generally speaking, the primary concern is people, when they're involved in a high-stress event, can have what they call critical stress amnesia, or they can have temporary memory holes, I call them, that sometimes it takes up to 72 hours before they truly get their full memory back about everything that took place. And for some, depending on the stress of the event, they may never remember everything that took place.
What are the concerns then with interviewing those people within that time period from a law enforcement perspective?
Well, the concerns, I think, whether it's law enforcement or anything, your primary concerns with conducting the interviews is how accurate the information is going to be. Has the person been able to reconcile and compartmentalize the event itself and start to accept what has taken place so that they can come forward with all the information? And then there's always the problem also that if I use myself as a reference, if I was involved in a shooting and I gave you a statement, an hour later, and then tomorrow I remember something a little bit differently because my memory is evolving and I'm starting to work through my own personal conflicts, whatever the case might be, I can have a varied statement now. And if too much weight is given, depending on the variation, I'm not talking about a completely different change in statements. I'm talking about slight changes or modifications. If too much weight's given to a change, now the person's expected that, well, now I'm lying. And the reality is it may take me some time to form everything back to be able to provide you with an accurate reflection of what took place.
Are there procedures that are in place to safeguard against those concerns with law enforcement officers shooting investigations?
Object as to relevance, Your Honor.
I'll rephrase it, just
Thank
so we're
you.
clear. In all of your experience, both law enforcement involved shootings and non-law enforcement involved shootings, are there policies or best practices that you're aware of as to any delay period or time concerns about interviewing shooters?
Best practice, you want me to tell you what the best practices
Yes.
are? My experiences have been, is any kind of delay, you get just a generalized statement at the beginning, an overview statement, nothing in depth, and then you wait, and generally speaking, in the law enforcement world, you have attorneys and PBA reps that immediately come in. That's just the general practice, that they come in and are present during any subsequent statement that is made.
Are there any suggested delays or waiting periods after the event before the law enforcement officer is set for an in-depth evaluation or an interview?
Well, training regimens indicate, and like the trainings that I've conducted and I've been to, is every time we teach a class, when you teach classes on force, you have to always talk to them about, unfortunately, ultimately the use of deadly force. And we always explain to them that, remember, you're not going to remember everything. You could take up to 72 hours before you're going to remember everything. And we always caution law enforcement because they have a high probability of being involved in a conflict like that. We provide them with that guidance right up front because we don't want anyone to misinterpret any statements. So the best practice is always to delay the statement itself.
Does delaying it tend to then give greater accuracy to the statement when it's eventually given?
Yes.
Your Honor, as to outside his area of expertise.
I'll rephrase it.
Thank you.
In your experience and in those situations where you've been involved assisting the departments that you've assisted in use of force events, and both as a law enforcement officer and also now as a consultant or an expert witness, in using that as an experience base, do you have an opinion concerning whether or not a delay allowing what you talked about to occur and pass results in more accurate and complete statements?
It's my opinion that you'll get a better statement from someone.
I'm close to being done. I was going to ask for a few minutes. Didn't know if this was a good time for a morning break.
Do you need a break? Ladies and gentlemen? They're good?
Okay, then I'm still going to ask for a minute, if I might.
Yes, they have.
There was another area of inquiry that I didn't go into just for a moment, and that would be specific to your firearms training. It was a while ago, but I think we've gotten the concept that you are fairly well trained in all areas of weapon systems, including firearms,
Yes, sir.
and that you actually teach other people how to handle and utilize firearms.
Yes, I conduct individual trainings for everything from basic handgun fundamentals through intermediate, advanced, and tactical application of handgun.
Did you have an opportunity to identify the type of gun that was used in this case?
Yes.
The Kel-Tec 9?
Yes, sir.
Okay. Can you explain for the jury, based upon your training and experience, the appropriateness for use as a self-defense weapon, or the lack of appropriateness as that gun as a self-defense weapon?
Any firearms, if the individual is willing to carry a firearm for self-protection and willing to do so in accordance, with all the training and backgrounds that should go with it, any firearm is a good selection. It's a matter of selecting the weapon system that's good for you. When it comes to that particular weapon, it's a 9mm. It offers some advantages, some disadvantages, and it all depends on the individual because it's a very personal selection when it comes to selecting a firearm for choice as far as self-defense.
I'd like you to focus on the safety. We have it available, but do you have enough of a working knowledge of the gun to be able to talk about without seeing it?
Yes.
Okay. And if I might have a little bit of leeway to lead you, it is a weapon that doesn't have an external hammer
Correct.
and no external safeties, correct?
Correct.
Then Do you believe that gun to be a safe weapon to carry?
Of course.
And why? Tell the jury, if you would, what safety, why is it safe, or how do you carry it in a safe way?
The most important safety of every single firearm is the person holding it. Because the reality of the modern day manufactured firearm is the only way that the firearm is going to discharge is if you squeeze the trigger all the way to the rear. A lot of people make assumptions based on, because like the Berettas and things like that, there are various Smith & Wessons, there's various products available that have external safeties. In other words, you flip the safety to the down position, gun will not function at all. The downside to that, when you consider a firearm for personal safety, is under high stress events, your brain's not going to remember, without a tremendous amount of constant and ongoing training, your brain's not going to remember that you have to flip the safety up before you can utilize the firearm. Because under stress, you're going to do what you did at the range. You're going to discharge it. So having those external safeties, as a safety person myself, they actually create a problem. This particular weapon being double action only, equivalent of double action only, there's no hammer to come back and go forward, but the trigger pull of 5 pounds or greater means that you have to intentionally put your finger on the trigger to press it all the way to the rear. And it has an internal safety, it has a hammer block safety, and the only way to defeat a hammer block safety on any firearm is to press and hold the trigger all the way to the rear. So in and of themselves, a lot of people misconstrue that because there's no external safety, it's not a safe firearm. That's not accurate. A firearm is as safe as the person holding it. So as long as you're not putting your finger on the trigger and squeezing it, it can be a safe weapon. There's a variety of weapons that are manufactured. This particular weapon does have an internal safety, which is the hammer block safety, but it also has, at least from my understanding, now I have not examined this particular firearm, but the Kel-Tec, I believe it's the PF9, has got like a 5-pound trigger, which is a good standard trigger pull because it makes it hard enough not to just get hung up on clothing, but not so hard that you have to have super grip to be able to discharge the firearm.
If there was testimony and evidence from firearm experts that the trigger pull was 4.5 to 4.75 pounds, is that in the range of what you're talking about, which is a safe range?
Yes, sir. Without taking it to gun manufacturers, I mean, if you look at the manufacturers, they say it comes with a specific 5-pound trigger. How they're achieving their numbers versus how somebody else is measuring it, I can't, that's beyond my scope for that.
There's testimony concerning an internal holster for a concealed weapon. Is that in any way an unsafe way to handle or to carry a weapon?
Carrying an internal, the idea behind a concealed weapons permit is you have to keep it concealed. Anytime you take a weapon and put it on the outside of your belt line, that's something a shirt has to cover, a jacket has to cover, and it makes it more difficult. So the most common things that you can find are in what we call in-pant holsters, where they slide inside the pants themselves, inside the belt line. Some hook around the belt, some have a clip that hook right onto the pants. The idea is it makes it easier to conceal so that you don't have to have a jacket. You could do it with just a pullover shirt or something to that effect. And it doesn't make it an unsafe holster or anything like that. It's a preference issue.
If in your firearm training, when you train both officers and non-officers, is it safe or unsafe to have a round chamber, I guess is the word, you use your word. Is that the way you should or should not have a gun?
This is like one of those debates from old. Having a round in the chamber means you can discharge the firearm immediately. Not having a round in the chamber means that in a high-stress event, you need to remember to work the action on the slide. In other words, pull the slide all the way to rear, let it go, so that it will feed a round. We go right back to the concept of why you don't have external safeties on a firearm. Under stress, under any type of actual threat, you may not have the time to work it, and more importantly, you may not have the memory that, oh, I've got to load one into the round, or a round into the chamber. Carrying it full, magazine full, and one in the chamber is the best way to carry a firearm. Because if you're carrying it for self-defense, if you're carrying it for self-protection, you have the equivalent of an unloaded weapon when you have a weapon that hasn't been quote-unquote charged. When you take a magazine and stick it inside a firearm, people will tell you, well, you've loaded the gun. That's not exactly completely accurate. You have loaded the magazine and placed it in the weapon, but you have not charged it. Therefore, the weapon is not actually loaded, because loaded would indicate that you could pull the trigger and something would happen. If you don't have one in the chamber, you pull the trigger. If the hammer is cocked, or if it's a Glock or whatever, and it's allowed to fall forward, it's falling on empty space, and now you have to work the action of the weapon to get it to work. Carrying it without a round in the chamber, why carry it?
And you mentioned a moment ago, one in the chamber and a full magazine. Is it appropriate or inappropriate to load it in the chamber and then put the additional bullet that's now been taken out of the magazine back into the magazine so you have a full magazine?
Again, my training and all my experience and what I train people to do is, if you're carrying a firearm and it will hold 7 rounds in a magazine and 1 in the chamber, or hold 15 in the magazine and 1, whatever it will do, load the chamber and make sure the magazine is fully loaded so that you have the full complement of ammunition that weapon is designed to carry.
In evidence are the bullets themselves that were in the gun, which are hollow point bullets. Do you have experience with those?
I have experience with the ammunition. I'm not a ballistics expert.
No. I'm just curious, is the hollow point bullet an appropriate self-defense bullet to carry, to utilize?
Yes. The reason being, when you look at a round-nosed bullet or something like that, it's kind of like what you see in the movies all the time with the big point at the top of the bullet. The problem with that is, there's a really good chance it won't, what we call mushroom. When a bullet impacts soft tissue, its design is to widen out to create a better wound channel, but the more important thing is it stops inside the soft tissues. Sometimes it exits, sometimes it doesn't. But the idea behind a hollow point is that there's this center cavity that when it hits, helps it widen out, which means it's less likely to over-penetrate. It's less likely to exit a person. Whereas a round-nosed round or a wad cutter or a variety of other ammunitions, because they're solid-nosed, when they hit, depending on how close they are, the energy is still going, it hasn't mushroomed enough, and it may actually exit, which means as a self-defense weapon, your goal is just to deal, hopefully, with one person, and otherwise, with the wrong ammunition, it can go through, and now you've got to worry about your background being struck by the round that you fired.
So in a very strange way is the use of a hollow point bullet, though it will cause injury to the first person it hits, less likely to cause injury to somebody behind the initial target.
Yes, because it's less likely to exit the first person that it impacts.
Thank you very much, Your Honor. No further questions.
Thank you, Carl.
Thank you, Judge. Mr. Root, good morning.
Morning, sir.
Did I hear you to say that your opinion is because the defendant discharged his firearm a single time, that doesn't evidence to you ill will, hatred, spite, or evil intent?
Correct.
Okay. Did you have an opportunity to listen to the non-emergency call he made just moments before discharging his firearm?
Yes.
Did you hear him refer language?
Yes, I did.
Okay. And you realize that the defendant didn't know Trayvon Martin, right? Hatred, spite, or evil intent.
I think that people like to give a little bit too much weight, because if you look at it in the context in which it was stated, his reference in that statement was addressing clearly addressing his frustrations from previous calls in which the individuals got away. His verbiage chosen may not be the most appropriate, but I don't necessarily mean that just because somebody has said that means that they mean ill will.
But the target of his frustration, you understand, was Trayvon Martin.
I would have to say that the comment, in my opinion, that frustration was being voiced at the fact that he's made numerous calls. The fact that he called, the other alternative is go, wow, these fellows always get away. I don't know what his general speech pattern is like in regards to how he refers to everybody else. So, in and of itself, I don't see that variable as being showing ill will.
Did he use either one of those terms during your entire conversation?
Geared toward me? No, sir.
No, at all.
I don't recall if he was asked specifically about that tape, but as far as the context being used to me, he did not call me that.
All right, and did I understand you to say that the most important factor about the safety of of any firearm is the responsibility of the user?
Sure.
So an irresponsible person can be really, really dangerous.
Absolutely. Any person that is reckless with their firearm can be dangerous, sure.
I want to talk for a moment about your connection with this case. You told the jury that you actually reached out to the defense, right?
Correct.
And tell the jury when you started your consulting company, that is what you're doing now.
I started doing consulting work at I want to say it was 2011, 2012, through Tactical Advantage Solutions. In 2013, I started Dennis Root & Associates, which is a private investigations and expert witness firm.
Dennis Root & Associates, you started earlier this year.
Yes, sir.
Okay. You understood when you contacted the defense in this case that this case was getting national, if not worldwide, attention.
Of
Correct?
course.
And you understood that there would be live coverage of this trial if you were to testify, right?
Yes, sir.
And assuming those cameras are working, you're on live television right now, right?
As far as I know, yes,
And
sir.
the name of your company is on live television, right?
I believe so, yes, sir.
So that's good for your company. You would agree with that, right?
I see where you're going. It's good for my company, but there wasn't really other options as far as approaching the state in the same way.
Well, didn't you think that you being a witness in this case might do your company some good? That is, you'd get your name out there?
There is no question that anybody that's seen anything about this case would be aware of the fact that it's getting media coverage. But anybody that does their homework about me knows the fact that I'm dedicated to finding the truth and supporting the truth. When I approached Mr. O'Mara about it, it's because I knew that the state would be able to gain access to somebody just like me with no issue. If I had approached the state about this, and let's say I determined whatever, that it wasn't going to be supportive for the state, or it would be, let's say for just instances that I found that I wouldn't be supportive, I now could not be in any way of assistance to the defense. However, if I reached out to the defense and I provided them with the opportunity and I found that, whoa, wait, I can't be any of assistance to you, I have not hindered the case in any way, and I could walk away without any problems and affecting in either way. So the fact that I gained some kind of media coverage from it isn't my fault, because those of us that are dedicated to the truth, those cameras are here. That's not why I'm here.
And isn't it true you've advertised the very fact that you are a witness in this case?
Yes, sir.
You've tweeted that out, right?
Tweeted? I haven't tweeted it.
How did you advertise it?
When I was put on the case, every attorney that I know knew about it. Obviously, in the fields that I go in, the attorneys, just like every other profession, talk. And then just this morning, I texted my friends to let them know that I would be testifying here today.
And in fact, you haven't been paid yet, have you?
No, sir.
Your agreement is you may get paid, you may not, right?
That's correct, sir.
Okay, but that's not your normal practice, right?
Actually, sir, it depending on the case that comes through, and if you looked at my background, you would know that I've done some things for free. I've done some things for some people for $20 an hour, and I've gotten paid up to $175 an hour. I really base it on the case that's presented to me.
Right, but didn't you provide me with an invoice sheet or the way that you bill clients?
For the expert witness, sir? Yes, sir.
Right.
Yes,
Okay,
sir.
well, that's what you're doing here today, right?
Yes.
And it's $1,500 initially, and then $125 an hour after that?
Yes, the way it breaks down basically is if I'm hired in as an expert, my general fee schedule is there's a $1,500 deposit, and my hourly rate is $125 an hour. That is for case prep and review. Then on the dates that I testify either by deposition or I testify in court, my hourly rate is $175 an hour, and that includes travel time and wait time.
And actually, you've never testified before a jury before, have you?
Excluding,
In court like this?
you mean excluding grand juries?
Correct.
Yes, this is the first time that I've actually testified before a jury on a criminal case. In an expert capacity, I've testified obviously as an officer in a criminal case numerous times.
Right, you've testified against police officers, right?
Testified against police officers?
Yes, sir.
I have been presented with cases that I found that the officer was wrong. Yes, sir.
And you've testified to that?
That one through deposition, not in
Correct.
trial. Yes, sir.
I mean under oath.
Oh, yes, sir.
All right. But you've never testified in a case like this where one person, and I mean in court, where one person shoots another and the shooter is claiming self-defense?
No, this was the first time I was ever presented with something like this.
And you yourself have never been involved in a police shooting, have you?
I'm fortunate enough that, no, I've never had to shoot anyone.
In fact, you've never had to discharge your firearm in the course of your career, have you? I mean, other than at a range?
Right, other than training sessions, scenario-based training, things like that, I've never had to discharge my firearm in the line of duty.
And you've never had to use any other type of deadly force in your career, have you?
Explain deadly force, sir. I mean, the things that I've had to do to people, I've caused injuries and things like that. And remember, deadly force just isn't about killing somebody, it's about causing serious bodily injury or death.
All right, but you've never caused someone else's death during the course of your career?
No, sir.
All right. And the first time you got information in this case would have been April of this year? A couple months ago?
Do you mean actual case stuff?
Yes, sir.
Oh, yes, yes.
And one of the things you did was you interviewed the defendant.
I did have a conversation with him, yes, sir.
And the purpose was to get a first-hand account of what he remembers.
Yes, sir.
And you would agree with me, would you not, that as a person charged with murder, he would have a motive to fit the facts his way?
Sure, anybody, if somebody was guilty of something they wanted to lie, you wouldn't lie to get yourself into trouble.
And you listened to the non-emergency call. I believe you testified to that, right?
Mr. Zimmerman's
Yes.
Yes, sir.
And you heard him describe Trayvon Martin in a couple of terms we've already talked about, but also as real suspicious, right?
Yes, sir.
And up to no good. You remember
Yes,
that?
sir. Yes,
You
sir.
remember him telling the dispatcher that he's got his hands in his waistband?
I do recall that, yes, sir.
And he told the dispatcher he's got something in his hands, right?
I believe he indicated that he thought he might have something. He wasn't sure. I don't believe he actually said he has something in his hands.
But you didn't ask the defendant, after making those observations, if he was concerned when he got out of his car.
Well, sir, just to proffer it, you say I didn't ask him anything. I don't think you were there, is
No.
what I'm trying to say.
Did you ask him that specific question? Were you
I-
concerned for your safety when you got out of the car?
No.
And I believe you'll recall in that phone call that he told the dispatcher that he went to the other side of the T. You're familiar with what I'm talking about. You've
I
been to
am.
the scene.
Yes, sir.
That he went to the other side of the T to get a street address, a house address, right?
Told the dispatcher that?
Right.
I
Or-
honestly don't recall.
Well, how about
that.
this? Did you watch the walkthrough?
Yes, sir.
Okay, did he tell those people he went to get a thing?
Yes.
Address? Okay, but he never did tell the dispatcher a street address, did he?
No, sir. As the conversation was concluding, I believe that he just let it rest with have him meet him at his truck, and then it was have him call me and I'll tell him right where to meet me. Something to that effect.
And what was your understanding about the length of time from the defendant between the time he hung up with the dispatcher and the time that he claims he was confronted by Trayvon Martin?
It was not that great period of time.
Okay, but you were interested in that time because you've told us the timeline is important to you, right?
Oh, absolutely, but you have to understand that when we make inquiries, and you have to remember that Mr. Zimmerman's statements to me only account for a very small portion of weight that I give to my overall evaluation of the case, because just like the gentleman said, I can't base it all off somebody that may make self-serving statements. But the concept of time that everybody constantly gets hung up on is the fact that whether it's 15 seconds, 30 seconds, a minute, whatever the case might be, everybody's concept of time is different. So I don't make a huge deal out of what his perception of time would be for this given period.
But you would agree with me that the only person that you interviewed who had firsthand information from this event, from the start to the finish, was the defendant, right?
Yes, sir. He was the only one that I actually spoke to in person outside of Mr. Pollock. I did interview Mr. Pollock, but unfortunately our schedules were such that I had to do it over the phone. I called him and spoke to him over the phone.
Right, but I mean, you listened to a bunch of other statements, audio statements by witnesses, right?
Oh, absolutely.
And you read their written statements, right?
Yes.
Nobody other than the defendant had a firsthand account from start to finish, did they?
Well, no. There was only one person there that's unfortunately still here with us that can do that.
And are you aware that it was actually 2 minutes between the time he hung up with the dispatcher and the time that Trayvon Martin's phone went dead? Were you aware of that fact?
Let me object, Your Honor. That would be a mischaracterization of the evidence, though he's allowed.
Okay, rephrase your question.
Do you know what time Trayvon Martin's phone went dead?
Can you explain to me what you mean by went dead, sir?
Yeah, when it cut off. Did you see the phone records in the case?
Yeah. Are you referring to when the call ended?
That's right. Did you see that?
I believe, the phone records from Trayvon Martin's phone. That one I can't, I think I saw them, but I don't know that I saw that particular variable in there. I don't want to say that I saw something that I didn't see.
Okay, well, you thought you were provided everything, right?
Yes, sir.
Okay, do you know whether or not you were provided Trayvon Martin's cell phone records?
There were cell phone records there. Again, I did not, the cell phone itself, to me, when I was doing my evaluation, the actual cell phone, I didn't see the weight that it had when evaluating the actual use of force event. So the timeline that you're relating to me, I can't speak directly to.
All right, did you have the testimony of a woman named Rachel Gentile?
Rachel Gentile.
Young girl from Miami, was on the phone with Trayvon Martin.
Your Honor, just not to interrupt, but I don't know he would know her by that name. So
Well,
I just,
Well, to the extent that that's an objection, overruled.
okay, well, I'll rephrase it.
Yes, sir.
Did you hear the testimony of the woman who claimed to have been on the phone
Yes, sir.
with Trayvon Martin? And did you hear her say in her testimony that the phone went dead shortly after, or right after she heard a bump when she was talking to Trayvon Martin?
Yes, sir.
Okay. And in creating your timeline, you said timelines are important, right?
Yes, sir.
Did you put together that it was 2 minutes from the time the defendant hung up with the dispatcher and the time that Trayvon Martin's phone went dead?
Using those timelines and evaluating on the timelines, there's a lot of questions that timeline creates, and being able to compare when the dispatcher's phone went, because I can't comment on how they were geo-synced or GPSed or anything like that for the accuracy of the times both by the provider and dispatch. But there's a lot of things that even Ms. Gentile said were taking place during that time that don't seem to line up either. So I want to be very cautious about how I just restrict myself to your timeline for that 2 minutes when there's other variables that if they played out the way that it was elicited from her would have a different outcome. So I just want to be very cautious in how I answer you with that.
All right, well, I'm not asking you to be cautious or the opposite. I'm just asking you, did you take note of the fact that there was a 2-minute gap between the end of each of those calls?
I did not give that weight, no, sir.
All right. And in your conversation with the defendant, he described this whole event to you, right?
Yes, sir.
Okay, but you didn't have him mark on a diagram where he claimed, or an aerial photograph where he claimed the confrontation began?
No, sir.
And you didn't have him mark how it progressed from where he claimed it started to where it ended?
I didn't require Mr. Zimmerman to create any kind of drawings or mark on any kind of pictures or anything.
And the defendant did not describe for you from what direction he claimed that Trayvon Martin approached him?
I don't as far as the direction, that would have been my failure not to ask. He said he was approached, and I didn't specifically ask, was it, if you mean by direction north, south, east, west, that would have been my failure not to ask that
Okay, well, I'm not talking about geography. I'm talking about front, back, side.
I got the impression he approached him from the front. During our conversation, it was pretty clear that he approached him from the front.
You didn't ask the defendant what hand Trayvon Martin used to punch him, right?
No, sir.
You didn't ask him how long it was between the time he got punched, as he claims, and the time he went to the ground.
I didn't ask him for specific times, and again, I reference back to what I already said, that when I interview somebody for a force event, or if I review a force event, time is so fluid. Actually sitting there saying, well, was it 5 seconds, was it 10 seconds? There's a period of time that took place. It's fluid, it's movement, it's evolving, so the presumption that once it begins, their concept of time becomes less relevant, so I don't lock anyone into a specific timeline in that regard.
I know, but the timeline is important to you, right?
The overall timeline, yes, sir.
Okay, and the defendant didn't describe for you how it was they moved from where he claimed the confrontation started to where they ended up?
No, there was no explanation as far as how they transitioned from that.
That fact doesn't speak to you about the level of the confrontation?
Well, understanding the dynamics of a combat event or a fight, you know, there's a lot of things that spoke to me about what he said and the other witnesses said in this case. And when you evaluate it and look at it, and how did you get from here to here? How did you end up on your back? Why weren't you on top? The evolution of the event itself and the imperative part that becomes down is when the actual physical confrontation began and when it intensified. Where they transitioned, being in combat events myself, being in fights and knowing that they start here and end up over here, well, how'd you get there? We were tussling, we were struggling. Oh, I apologize. We were involved in this person-to-person conflict. How they transitioned from one spot to the other spot, given there was no major event that took place at that point, I didn't try to narrow him down on a time for that.
Okay, but I mean, you didn't ask him, not this time, you didn't ask him how they got there, right? What happened in between?
The fight started here and it ended up on the ground there.
Right,
And
but
I
you
did
didn't
not
ask him-
inquire from him specifically how he got from this point to this point. No,
Right,
sir.
as in whether or not they were rolling over there, or whether or not they were fighting standing up over there to get over there, right?
Right, I would presume based on the physical evidence, I wouldn't even presume they were rolling over there, but, you know, whatever the struggle took place, I personally didn't inquire about that, no, sir.
Okay. And you were asked by the defense counsel if you took into account the placement of the defendants, I think it was a key fob with a flashlight on it.
Yes, sir.
Isn't it true you didn't ask the defendant about his losing personal property throughout this event, where and when he lost things?
I don't recall. I can't say honestly whether I asked him that directly or not. I don't think I did, but I don't recall specifically, I'll be honest.
You didn't ask him how he lost his keys or the little flashlight, did you?
No, because as far as that point, with the way you phrased it like that, I don't know what you're asking me there. I didn't ask him specifically how you lost your keys. I didn't ask him how he lost his keys.
were dropped, right?
Well, I saw the photograph and evidence also that there was a picture with that item right there, right by the sidewalk on the grass.
Did you ask him how he lost this? And for the record, it states 145?
No, sir.
Okay. This, by the way, would that be an impact weapon?
May I hold it? I wouldn't.
Sure.
What's it made out of? How much does it weigh? I mean, anything can be an impact weapon. Sure. Yes, you could use this to strike somebody.
I mean, so
Absolutely.
when you were testifying earlier about your familiarity with impact weapons, that would be one.
This most certainly could be used in that form or fashion. Sure.
And the defendant told you that his head was repeatedly slammed into concrete?
His words were, excuse me, his words were his head was slammed into the concrete.
Okay. You didn't ask him how many times?
No, not how many times it happened. Again, we go back to perceptual distortions.
All right. And you didn't ask him how his head was slammed, right? I mean, whether Trayvon Martin grabbed his ears, or grabbed his face, or grabbed his jacket?
No, I didn't ask him specifically how his head was being impacted into the concrete. Again, generalized statements from Mr. Zimmerman himself because he doesn't account for the overall weight of my opinions. And there are many ways, but the way he related the information, despite there being many ways for his head to contact the concrete, the manner in which he related the information about being struck in the face and his head striking the concrete, it could have been during the strikes, but his perception was that the downward blows, his head hitting the concrete, his head was being slammed in the concrete. And I even got that from the video that you recommended I watch.
His video, right? The one.
No, sir. The one you mentioned about Hannity.
Right.
Sean.
Right.
Yes.
He said it then too, right? Didn't he?
Yes, sir. And if the verbiage that I looked at there also, again, perceptual distortions is he's being struck in the face and his head striking the concrete. We can put weight to various things, and, as an expert, each and every one of these things in and of themselves may not account for everything. It's the totality of everything. And what caused his head to hit the strike or to strike the concrete? It's clear that his head was in contact with a hard surface based on the injuries on the back of his head. The striking of the face, could that have been what caused him hitting the concrete? Sure. Was he being pushed down? Another option is, if we think about Mr. Good's statement, is because Mr. Good's statement adjusted from when he initially gave his statement, if it was not always striking but pushing, if Mr. Zimmerman's trying to rise as he shoved back, even if it was a pushing down motion, could that result in his head striking the concrete? Absolutely. Regardless, from my perspective as an expert looking at it, there's a variety of ways in which his head could have impacted the concrete, but it's clear that he was struck and his head did make contact with the hard surface.
Right. And I think you said you reviewed some medical records?
Yes, sir.
Okay. Did you review the medical record that where the woman measured the longest laceration on the back of his head is 2 centimeters?
I don't want to quote the distance. Yes, there was they weren't that large. Is that what you're asking?
Right. Well, 2 centimeters, right? That's less than an inch.
Oh, okay, I'm really not good with that. I got to be
Okay.
honest with you.
You remember-
If
you remember-
2 centimeters, I'll say yes. But if that's less than an inch, I really.
You remember the length of the other one? Half a centimeter? Does that sound right?
One up and to the left. Okay. Yes, sir.
You didn't ask the defendant about whether any blood from his nose got into his eyes or his mouth, did you?
Well, I didn't need to ask about the blood getting into his eyes because at the time the photographs were taken, they seemed pretty fresh and there was no blood all around his face. And as far as in his mouth, I didn't ask that, no, sir.
And you didn't ask the defendant whether or not he tried to cover his face while this was going on, did you?
No, sir. I just merely asked him to tell me what took place.
And you didn't ask the defendant whether or not he tried to strike Trayvon Martin?
No, I didn't spend a lot of time asking him a lot of things.
The defendant never told you, did he, what he was doing with his hands while this was going on?
No, sir. I don't recall him saying anything.
You talked about vantage point.
Yes, sir.
You'd agree with me that out of all the people you heard from, either talked to or had written statements or audio statements, the person with the best vantage point would have been the defendant, right?
Of course. He was there through the entire thing, and he was an active participant.
And you would agree that if Trayvon Martin had lived, his vantage point would be important too?
Sure, absolutely.
The defendant told you in his statement that Trayvon Martin was straddling him, right?
Yes, sir.
And you understood that from the context of your conversation, that Trayvon Martin was over the defendant's belly button, right?
It was over his waist area.
Well, didn't you say previously over his belly button?
During our conversation that we had in deposition, and I was actually not provided with a transcript, so I'm just going off memory here. I believe we discussed it and we identified it could be the waist. I mentioned that a high mount, it can be over the waist, the belly button area, but we also discussed it and I mentioned that it could be down around the waist, upper thigh area.
Would it refresh your recollection to see a transcript of your deposition, since you haven't had one, to refresh yourself on what term you used?
Sure.
Counsel, page 53,
Just would object to the attempted impeachment.
He's having him review it first.
Question was answered.
Judge,
He's entitled to show him the deposition if it's,
If he suggested he can't answer the question, doesn't remember it, he answered it.
if the answer is different.
Judge, I'm entitled to refresh his recollection.
Okay.
If I may
Could you
approach-
please state the date and time of the deposition?
Yes, ma'am. Well, Mr. Root, you will recall it was a week ago Saturday, right?
Yes. It was
Okay,
a
Saturday in the morning?
Yes, sir.
We all appeared on a conference call?
Yes, sir.
Okay. And you were under oath at that time?
I was.
All right, counsel, page 53, lines 10 through 16, if I may approach. Let me just ask you to review that highlighted portion and see if that refreshes your memory as to what your understanding was as to where Trayvon Martin was specifically straddled on the defendant.
Yes, sir.
Okay. Where was it?
In the area of his belly button,
Very good.
not directly on it.
Well, by area of belly button, you mean here?
No, I object that he needs to read the entire
You
question.
can do that on your redirect.
And, okay.
By area of belly button, do you mean here?
If that's where your navel is, yes, sir. The area is, it's either going to be below that, it's going to be in the area. I wasn't trying to say that it's on his belly button.
You recognize this as being a human-type figure, right?
Yes, sir.
Okay. It's actually got a belly button, right?
It surely
Does
does.
it appear to be anatomically correct?
For the belly button, yes, sir.
All right. So, as the defendant described it to you, is this the way he described it, in the area of his belly button?
Well, what's really important right now, sir, number one, you've got your knees up pretty high in his waist. If you want to slide down just a little bit more so that you're
Okay.
in the, there you go. Have a squat. I can't see your crotch, but in the area of his belly button, yes,
Okay, well,
sir.
here's his belly button. Am I in the area?
Yes, sir.
Okay. By the way, did you have the defendant do this?
No, sir.
When you talked to him, you didn't have him do that?
No, sir.
Okay. If this person, this mannequin, were carrying a firearm on their waist, where would the gun be right now in relation to me?
Would be at your left inner thigh.
Right here, right?
Yes, if he was right-handed, it would be at your left inner thigh, yes, sir.
Right, underneath my leg.
Yes, inside your leg.
Okay. Were you aware that the defendant described to his best friend that when he slid down, the defendant slid down, that Trayvon Martin was up around his armpits? Were you aware of that?
No, I've not heard that, no, sir.
Okay, well, where would the gun be now?
Now the gun would be behind your left leg.
Okay. The defendant did tell you, though, as well, that at some point he slid down further between Trayvon Martin's legs.
Yes, he did indicate that he was sliding down, and I believe that's how the jacket came up, exposing the firearm.
You know, if I can have just a moment. You didn't ask the defendant how he was able to get his firearm, did you?
No, sir. He explained that he reached down and grabbed it.
But he also explained that Trayvon Martin was in the area of his belly button, right?
Yes, at one point,
Right.
the whole thing's fluid, so it's not like Trayvon
Right.
just got in one spot, he moved all around, and
He
it
said
didn't
at
move.
first he was in the area of his belly button, and then he actually slid down. That happened after, right?
Yes.
And then he said that's when he grabbed his gun.
Yes, after he had slid down, the jacket came up. you're implying that Trayvon didn't move so that it wouldn't be accessible, but we have to remember in a dynamic event, it's not just one person doing all the movements, so we have to take into account both sides of the equation as it's interacting.
Well, did the defendant tell you that Trayvon Martin slid down? He didn't do that, did he?
No, sir.
You were asked if you reviewed the medical examiner's report.
Yes, sir.
You did.
Yes, sir.
Do you remember the trajectory of the bullet being referenced in there at being at 90 degrees?
Yes, sir, and I believe front to back.
Right. Wouldn't that be consistent with Trayvon Martin getting off of George Zimmerman and George Zimmerman raising the gun and firing it?
Well, when you talk about angles of anything, sir, it could be consistent with any kind of movement. We could say it could happen that way, it could happen another way. There are various ways that you could have it happen, and, you know, you weren't there, I wasn't there, so the information that we have is what
On the
Mr.
defendant, right?
That's correct, sir.
Okay. Judge Malperson, Mr. Mann?
Yes, you may.
I mean, your information came from the defendant.
Not all of it, sir. Your
Well-
indication is that the only person I spoke with is the defendant, and that's not accurate.
I'm talking at the time the shot was fired.
The time the shot was fired, the information that I culminated on opinion on that is a culmination of everything. The only person that could provide any insight into at that very second that was there was Mr. Zimmerman.
Okay. And he said he was in the waist area, and then the defendant may have, or Trayvon Martin may have slid down. And my question to you is, would it be consistent, the 90 degrees, if Trayvon Martin had been backing up and the defendant raised his gun and shot at 90 degrees?
With you at that angle, 90 degrees to what, sir? When you talk about 90 degrees, we're talking about
Right.
this degree.
Right.
So if it's front to back 90 degrees and you're standing there and you're holding the gun up, already you're at least 45 degrees where you are because he's laying flat on the ground.
Right, but if
and you're
Trayvon
standing
Martin,
straight up.
if Trayvon,
One at a time and slow down, just a little.
I apologize. If Trayvon Martin's backing up, could not the defendant have shot him at a 90-degree angle?
If Trayvon Martin is backing up
Correct.
and you're saying that Mr. Zimmerman is laying on his back and he brings the gun to bear on Trayvon, if he's backing up, then now that suddenly that bullet's going to go straight in, back, front to back
I'm
at a
asking you,
90 degree.
could he shoot him at a 90-degree angle?
I think I'm getting really lost in this 90-degree thing is really, I don't want to misinform the jury with my answer.
Okay, well, 90 degrees was what you read in the medical examiner's report, right?
That's correct. And my interpretation was 90 degrees front to back was like it was a, for lack of a better word, I'm not a medical examiner, but my interpretation of the information provided was that it would give it a front to back, for lack of layman's terms, like a level entry,
Right.
not an angled entry.
Correct.
So as this event is transitioning and you're coming back, if this comes back, then we maintain that.
Right.
If it's a struggle that's forward, so in your 90-degree reference, I want to be very clear that I'm not trying to say that the manner in which you're demonstrating visually right there, with him raising his gun up, with you sitting back, I don't know how you could get a 90-degree entry if you're sitting straight back like this.
Well, I'm not sitting straight back. I'm just,
From my perspective is all I'm trying to say, sir, is
Okay.
it looks like you're more vertically upright and he's sort of like the two of you form a 90.
Right.
And if the two of you form a 90 where you're straight up and he brings the gun to bear just based on the dynamics of his arm, there wouldn't be a way for it to go straight in. There has to be mutual movement to keep them within
right.
line.
As in, if the defendant started to sit up and Trayvon Martin was getting up, are you saying that there couldn't be a 90-degree angle?
Am I saying there couldn't be a
Right.
90-degree angle with
Right.
him in a half-up position
Right.
and you trying to get up? If the bodies become in line, it's as long, in order, from my understanding, to maintain the entry, we're going to have to maintain some relativity between the two persons, right? So the relativity, I can sit here and say the same thing, that if I'm laying completely back and you're more forward, I can get a 90-degree entry. If we're both coming up, you're asking me to bring up a conclusion, could it happen that way? The answer is absolutely yes. If he's getting up and he's getting up together, sure. There's no way I can sit here and say that, no, you couldn't have two people that are maintaining alignment not have that entry.
And you were also provided the firearms report, right? And you learned that it was a contact wound with the clothing that Trayvon Martin had on,
Yes, sir, the clothing.
but it wasn't a contact wound with his chest.
Correct.
So that would be consistent with Trayvon Martin leaning over when he got shot.
Yes,
Right.
sir, sure.
Okay. You were asked, or you actually spoke a little bit about the lighting, right?
Yes, sir.
Did you, you actually went to the scene for the purpose of getting idea of the lighting, right?
Yes, sir.
But you didn't get an idea of the lighting, did you?
No, I failed to go take into account the change in season. So when I got there, it was still daylight or dusk area.
And when was that?
Off the top of my head, I can't remember the exact date, sir. I think I might have told you in deposition, but I don't remember exactly off the
Could you
top of my head.
ballpark it? Was it in July?
July, no.
Was it in June?
Maybe early June. I don't remember the exact date in which I attempted that.
So you went to the scene to try to get an idea of the lighting, and
Yes,
the
sir.
sun had not gone down?
Correct. It was not completely set.
Right. So you didn't wait until it had set?
No, sir.
And you didn't go back?
No.
When it was dark, some other day?
No.
The defendant told you that Trayvon Martin reached across his body to try to get the gun?
He mentioned that, yes, sir.
But he never told you that Trayvon Martin actually touched the gun?
I don't believe he said he actually touched the gun. He felt him moving toward the gun. He perceived that he was moving toward the gun.
Were you aware that the defendant told his best friend that Trayvon Martin actually touched the gun, grabbed it?
It's possible he said that.
I mean, you don't...
I don't think it would affect, whether you're reaching for it or grabbing it.
I'm just
Six one
asking
half of
you.
the that's in the other.
Mark Osterman, does that name sound familiar?
Yes, sir.
Did you review his testimony? Or his statements, pretrial statements?
I reviewed his statements, but I focused in on the people that actually had witness accounts. Again, my job as an expert is to look at the event, not hearsay that comes from somebody else that they're saying, because number one, dealing with man to man, I have always got a concern that I haven't met too many men whose egos don't enter into it when they're having a conversation with somebody. It's usually generally women that can keep their composure and not feel like they're, have to say something that makes another guy feel better about them. But the statements I focused in on were the events that took place there, not 110% what somebody else said they heard somebody say.
But part of your focus, a good part of your focus was the only witness who could tell you from start to finish, and that was the defendant, right?
No, the totality of the event. Again, you're trying to narrow it down, and it's interesting because we could narrow it down to any specific part that you'd like, not just the one part that seems to be advantageous. When we look at the totality of the event, I reviewed everything from everybody that can provide information about the event itself. It is true, the only person currently that we can gain information from that specifically can address the event that unfolded away from the calls and away from the one person is Mr. Zimmerman. Not Mr. Osterman or anybody else, just Mr. Zimmerman.
Was your conversation with the defendant important?
Of course it's important,
Okay.
sir.
So wouldn't his statements to someone else about the exact same event also be important?
Sir, I've listened to the statements related by other people, and it always comes back down to the fishing story. That even though somebody may want to be supportive, the human element, the human mind, likes to fill in the blanks. It's a natural human thing that we see something, and if we don't understand it, the creative side of our brains will help us fill it in. They will find a way. And that is another reason why if you wait too long and you allow people to get too many interactions with other people, the statements can change because now they have outside influences. As far as what he said to somebody else, bringing in is adding more importance to me at that point, that would be inaccurate because the information I need is about that night, not somebody else's interpretation about what somebody else said.
And you talked about the use of force continuum, right?
Yes, sir.
And explain that for the jury what that is.
Like I said, it's a force continuum. It's a systematic approach to escalation and de-escalation of force, taking into consideration background training experience, weapons availability, and the totality of an event. It's basically saying that if X happens, you can respond with Y. It's
Right.
the idea is to give an objectively reasonable connection between two behaviors.
And if Trayvon Martin was backing up as I demonstrated a moment ago, that would be a de-escalation of force, right?
Sure, if a person is disengaging, it would be a de-escalation,
Right.
as long as they're not disengaging to go to another weapon, but
Right.
just in general terms, like you mentioned, of backing away, if I was giving up, that's a de-escalation.
You also mentioned in the force continuum, there are options, right?
Yes, sir.
Okay, and you would agree with me that someone in the defendant's position had other options?
I would disagree with you, sir. You're telling me that somebody in the defendant's position, the moment that perception became a deadly force encounter, the only option that's justifiable would be the actual application of that level of force. I mean, we can sit here all day long and come up with 1,000 things that may have been able to be done, but the reality comes back to what a person is perceiving to be their reality and what the approved responses are for that given reality.
Okay, but you don't know what was in his head, do you?
Based solely on the information that I reviewed, based on what I heard from the 911 calls, based on the inclusion of the physical evidence of the injuries to his face and the back of his head, and the fact that, in my opinion, most of that information meshes together. So I can draw my opinion and I can come to the conclusion of what I believe the perception to be. And based on that perception, I know what a generalized outcome could or should be.
All right, when you said 911 call, you talking about the one with the screams on it?
Yes, sir.
Okay, you're not telling this jury that George Zimmerman's the one screaming, are you?
I'm not telling the jury anything other than what I just told you. If you take into consideration the 911 call, you mentioned whether it was him or not. I wasn't there, I couldn't tell you that. I can tell you that based on Mr. Good's statements, that he believed that the screams for help were coming from the gentleman on the bottom, otherwise he would have heard an echoing sound because it wasn't facing away from him. And if you take that concept and you include it in, then it would fall into play that those screams were Mr. Zimmerman. But in the same token, if you're on top trying to hold somebody down to disengage, as you've indicated, I'm trying to get away from him, and somebody now is coming out saying, hey, stop, and there's no indication from you as the person on top trying to hold somebody back that you need help, and that your inference is that those screams were his help, why was there no acknowledgement of the person behind him? So again, any one of these things in and of themselves don't tell the whole story. It's about taking all of the information and considering all of the components and coming to a conclusion.
Let me ask you this. In your experience, if Trayvon Martin or anyone would have been in that situation and would have been aware of the defendant's gun, either seen it or felt it, would you expect them to scream for help?
You're asking me if somebody saw, if I am beating the crud out of you and I suddenly know you have a gun, would I expect me to be screaming for help?
Would that be unusual for a person who saw a gun too?
If I am, you just said if I was Trayvon Martin in that situation and we take it to the place that we've gone with the physical evidence where I'm the aggressor, I'm on you and suddenly I see you have a gun, my first instinct as the aggressor is not going to be to scream for help. My first instinct as the aggressor, if I'm the one that's being the aggressor, is to go for the weapon that's going to help me continue my aggression, not prevent it from being implemented to stop me.
Okay, my question was, it would be unusual for a person who saw someone that they were in combat with a firearm, would it be unusual for that person to yell for help, in your experience?
I want to make sure I'm clear because you just said, would it be unusual for a person involved in a combat situation to suddenly see a gun and scream for help? Is that the question that you, I want to make sure I'm very clear on because I don't want to misinterpret this because I want to be careful on what I say with what you're asking.
I'm trying to make it more simple. I mean, if a person sees a firearm, would it be unusual for them to yell for help?
If an average individual saw a gun and it was pointed at them, I would say absolutely not. Anybody looking down the barrel of a firearm, if you're able to vocalize something, would probably yell for help. I mean, if you're looking down the barrel of a gun, I would hope if you're looking down the barrel of a gun, you'd be in fear for your life.
All right, back to the options. We kind of got away from that. There are other options that George Zimmerman could have used to get out of that situation, right?
Based on my understanding of his physical skills and things, he wasn't physically trained. You know, asking of options, we go back to what we talk about for subject factors, variables involved in an individual in the event. What's your background training and experience? You know, one of the training instructor certifications I have is in one-on-one control tactics, and that is a ground fighting discipline. So yes, there's a lot of options that are available, but if I have no background training or experience to lead me down those paths, there's nothing else. So I am very limited on options. There are always options in every force event. It's just a matter of what you as an individual see as being your options.
All right, but the defendant didn't use any other options, did he, other than pulling out the gun?
Well, I mean, if we go down the path where he was the one vocalizing, he did scream for help, he elicited assistance from other people, there were other options. He obviously continued to try to resist. He was doing, as you know, I guess they refer to as the shrimping technique, trying to get and move around. You know, as far as drawing a conclusion, I don't know what else he could have done based on his abilities, because, not to be offensive to Mr. Zimmerman, but he doesn't seem to have any.
You're not suggesting that the defendant was just laying there getting hit, right? And he wasn't
Absolutely
defending
not.
himself.
No,
He would have been
sir.
defending himself.
I would presume that at a minimum, he would be struggling in some form or fashion to create some kind of gap or distance. Instinctually, that seems like it would just be a normal thing.
Did you say that there's a verbal component to the use of force?
Absolutely.
Like telling someone who you are?
Well, the verbal component is anytime you interact with people, you can escalate or de-escalate an issue based on communication. If you know, the levels that when we speak about law enforcement, you have presence, and they offer different levels of resistance. For us, it would be, you know, you tell them, stand over here. No, I'm not doing that. Well, that's verbal resistance. That's a verbal communication. The officer's response can be verbal, which would be, you're under arrest, come stand over here, blah, blah, blah. In the individual or civilian realm, verbalization can be screaming for help. It can be telling the person, no, stop, don't, whatever those cases might be. That's the verbal component.
And it also could be like telling them who you are. Like, I'm a resident here. I'm a neighborhood watch person.
Absolutely. You could tell them that I'm Dennis Root and I'm here to say hello.
And you could tell them what your purpose is, right? Like, I'm a neighborhood watch person, and I'd like to know what you're doing.
Yes, yeah. If you afford the ability to communicate with somebody, it's always a good idea to introduce yourself and advise them.
I mean, you would do that before using force, right?
Well, sir, again, you're asking me what I would do, and I can tell you this. There's a lot of things that if I was in that same situation, I most certainly would have done differently. But the reality still comes down to when you say that somebody that's based on, again, going off 911 calls, this gap, whatever it happens to be, he's in an environment, he's doing what, I mean, the golden rule of community-oriented type programs is if you see something, say something. That's the whole idea. You know, and Mr. Zimmerman has a history of that. He reported, you know, by the calls, everything. He's had numerous calls from a variety of reasons, from children to suspicious persons. The interaction component, is he responsible for when you walk up to somebody and if they're in a suspicious area, hey, I'm a crime watch person, if you have the distance and ability and that comes to mind, that's fine. But that also takes training and thought on the forefront. However, on the other side of that coin, if I'm suddenly surprised by something, communication may not be the first thing that comes to my mind, especially if it's a blind side of some type.
You did talk to Adam Pollock, right?
I did, sir.
And you actually talked to the defendant about some of those classes, right?
Yes, sir.
But you didn't ask the defendant how long he had been taking those classes.
No, sir.
And you would agree with me that should have been asked.
No, sir.
Did you not say that not getting that information was a failure on your part?
Yes, and as I would say anything, just like I did about asking the other thing, anything I don't ask, I always take on as my responsibility. It doesn't change the outcome of an event. It doesn't change the total influence. The fact remains that if he had been spending 3 years and was just barely able to get into a grappling ring with somebody where he can say uncle, and he spent 3 years boxing and he can't even get a ring with another person, it really is a moot point about how long he's been doing it. The end result is I got the information from the source that actually can give me a neutral opinion because he was the one doing the training.
Because the defendant's not neutral?
Sir, just like we said, and you said it yourself, you have to take it with a grain of salt. The only way that I can come up to a neutral opinion on anything is by giving minimal weight to Mr. Zimmerman and trying to find the information from some other source. Unfortunately, depending on the variable that we're asking, the only source may be Mr. Zimmerman, but sources that I can get information from somewhere else other than the defendant, I would seek that because that gives me more possibility of getting the truth rather than what some quote-unquote defendant wants me to hear.
All right, so you didn't ask him for how long he had been taking the classes, like over a year? You didn't ask him?
No, sir.
You didn't ask him how long each class was, like 2 hours?
Generally speaking, when you look at any of the combative sports, you're looking at an hour and a half to 2 hours because of warm-up, stretching, the actual activities, cool down, and stretching again. So I probably didn't ask that only because the general guidance on that for just physical technique type classes, that seems to be the norm.
And you talked a little bit about Trayvon Martin. You wanted to know about his physical ability, right?
I would love to have known totally about it, yes, sir.
But you said, yeah, I believe your words were he was physically active.
That was my understanding, yes, sir.
Because you had information that in middle school, he played football.
Again, and I believe I even said it, before this case began, there was information in the media.
Your Honor, can we approach for a moment?
Yes.
Sir, I believe you testified on direct that you were told that he played football in middle school. Is that right?
Yes, yes, sir.
And you had his height and weight, correct?
Yes, sir.
5'11" and 158 pounds.
Yes, sir.
You got that from the autopsy report?
Yes, sir.
Judge, if I can have just a moment.
Yes, you may.
You were asked questions about basic certifications for various weapons, right?
Yes, sir.
And you're aware that the defendant had a concealed weapons permit?
Yes, sir.
So he would have taken a course for that?
Yes, sir.
Isn't a person who is licensed to carry a concealed firearm supposed to disclose that to the police when they talk to him?
There's no law about it. I mean,
Aren't they advised to do that? When you speak to law enforcement, you advise them that you're armed?
You mean in person?
I mean, over the phone, in person, at all?
Not over the phone. Whenever you interact with a police officer, if you're carrying a concealed weapon, obviously, traffic stop, interaction on the street, something to that effect, we tell everyone that when you interact with law enforcement, the first thing you want to do is make sure your hands are clearly visible and just let them know that you have a concealed weapons permit and you are carrying a firearm. We don't really ever address something over the phone. I mean, sure, I guess it would be nice, but we don't
You
address
said,
it.
well, to be clear, the defendant did not advise the dispatcher that he was carrying a firearm.
No.
And you said that you have a criminal justice degree, correct?
Yes, sir.
Were you taught the law of self-defense in any of those courses?
I've taught law laws, yes, sir. I'm sure we covered that.
Were you taught fact scenarios that constituted self-defense?
I can't say that we were caught fact scenarios. Every instructor that's responsible for relating information relates it differently in every class. I can't speak to how everybody does it. I know how I relate the information. but I can't speak to how everybody else does.
And it was your opinion that a weapon was not used on the defendant?
I didn't see, are you talking about Mr. Zimmerman? There was no weapon used on Mr. Zimmerman by Mr. Martin?
I believe that's what you said.
Yes, I didn't see any indication that a weapon of any type was used on him.
You did see an indication that a weapon was used on Trayvon Martin.
Did I see?
Did you see an indication that a weapon was
Of course,
used on
he
Trayvon
he
Martin?
was shot, yes, sir.
You know, have just a moment.
Yes, you may.
All right. Mr. Root, in listening to the non-emergency call and your conversation with the defendant, he told you he was following Trayvon Martin.
I think the term that he used was trailing, which to me, it means following. I mean,
Well,
it's the same thing.
Okay. I mean, do you remember when Sean Nofke, the dispatcher, asked him, "Are you following him?" And the defendant said,
Oh, yes, sir, absolutely. In the 911 call, absolutely. He asked him, are you following him? He said, we don't need you to do that.
Did you read the defendant's written statement?
I'm sure I would have.
It
I
was
can't
around
recall.
4 pages handwritten.
I am confident I did. I just don't recall exactly what he had written. I mean, if you ask me a question about it, if I don't know, I'll honestly tell you.
Okay.
I've read so many of the documents, it's,
I understand. Do you recall the term that the defendant used to refer to Trayvon Martin in that written statement?
no, that I honestly, I don't recall the term that,
You don't recall the term suspect?
okay. I don't directly recall it, but I would take your word that he wrote suspect there.
All right, you would agree with me that that's a police term, right?
Oh, sure, it's
That's the
a
way you
term
do
that it's also a crime prevention term also. It's anybody that you interact with, they utilize the same verbiage, even though you may not get it, most certainly, it's like saying civilian, and I get yelled at by a friend of mine because it's individual. But in law enforcement term, every individual is a civilian. So for suspect, we refer to as being the other person, the bad guy.
Judge, that's all I have. Thank you.
Yes, Your Honor. So I'm clear, would you consider a big old piece of concrete a weapon if I hit you on the head with it?
If you hit me in the head with concrete, yes, I would
How about if I
consider
just
that.
took your head and smashed it onto concrete? May I use your dollar for a moment? Of course. Let's just use this for a moment because I want to follow up on some of Mr. Guy's questions. So, George Zimmerman, Trayvon Martin. Were the injuries on Mr. Zimmerman's back of his head consistent with someone doing this on cement?
I don't think so.
How about this? How about somebody resisting the attempt? The injuries, the two lacerations, could that have come from cement? If somebody was resisting me pushing down like this?
I believe so. I believe it was a culmination of downward force, whether it was from pushing or striking, and I know clearly by the injuries to his face, and that would drive him back, his head striking hard into the concrete.
Would you expect, based upon your training and experience, that somebody getting their head struck on the cement would attempt to resist it happening?
Of course, they would, normal human instinct would try to move away from the pain stimulus, which would just create another gap to be driven back.
And would that occur not only the first time, but every subsequent time?
Whether it's a push or a strike, every time you drive a strike or push straight downward, the body goes until it hits an object that'll stop it.
Did you see the pictures of the injuries that showed punctate bruising and lacerations on the side of Mrs. Zimmerman's head?
Those were when I said blows raining down earlier, those were the things that really caught my eye that supported the fact that it was a striking and not a pushing so much because of all of the, lack of a better word, injury or damage that I saw on the side of the head. There's swelling all around his head. It's not just the facial area, it's all around the
Well,
front
those
portion of
injuries
his head.
consistent with somebody pushing a head down to the side. You see me move it to the side like that. Is that similar to that, hitting cement?
It could be. It could be that, or it could be punches as well, driving those strikes in.
And then on the other side, would the injuries consist in hitting it down on the side, on the left side of Mr. Zimmerman?
It could be, and and just like Mr. Guy pointed out, if Mr. Zimmerman is on the bottom and he's not just laying there, he is moving, whether he's trying to defend himself, trying to do his sliding techniques or whatever they are, as he's turning his body or his head in those efforts, it's going to redirect and realign, so whatever push or punch comes in next, if he's turned this way, it's going to be a strike to a side, the front. That's all indicative of an ongoing combat event.
Now, talking about the angle, Mr. Guy, I think, was suggesting that we need to stay focused with the angle of entry of the wound being basically 90 degrees, so it's straight in, correct?
That's what he said, yes.
Now, that could happen, of course, as Mr. Guy suggested, maybe something like this, if Mrs. Trayvon Martin is trying to now back away at the end of the 45 seconds of screaming, correct?
Correct.
Do you agree that that's a possibility?
Absolutely, it's a possibility.
Do you have any evidence that beyond a reasonable doubt that is what happened?
No.
Could it happen this way?
Yes.
Same angle. Could it happen
Yes.
this way?
Yes.
Could it happen if Mr. Martin is reaching back with his hand for yet the final strike or something like that? Could it happen right there when he's coming back over?
As long as the alignments of the body stay within those same relative positions, where they are within that axis of movement, it's a possibility.
Now, you know that Mr. Zimmerman was in fact able to get his gun out of the right side hip, correct?
Yes.
Now, somehow he got to that, correct?
Correct.
How much weight do you give to Mr. Zimmerman's ability to disclose and to advise exactly how that happened?
Not a lot,
Why not?
because when he became aware of the presence of the firearm, he reached for it. The
Mr.
transition under stress, the transition of how it got into the hand is kind of moot. And, my background, training, and experience, I've interviewed numerous police officers involved in shootings. And frequently I hear, I shot, well, when you draw, they're not clear on how they got into position. They just know they did it. Instinctually, survival mechanism, whatever it is, the point still remains, the gun was in his hand and he did in fact discharge it.
And he discharged it in a way that was in contact with billowing clothing that was 2 to 4 inches away from his chest, correct?
Correct, which, when we think about the movements, if he's moving with I think it was an Arizona iced tea in his jacket, the hoodie, transitioning, leaning forward, if that body position's there, that tee's going to keep it away as they transition back. If he's at some point leaning too far back or whatever, trying to get up, that tee's going to be pushing the shirt the opposite direction because it's going with the motion too. At what point and where they were, I can't specifically say.
Okay. In the context of your training experiences, the way combat events and how they occur, is it possible that at some point Mr. Martin was in fact up here?
There's no question that it's possible because during the event, when he says he's sliding down, I don't expect Mr. Martin to be able to match him move for move. Is it possible that at some point he was up on his chest? Yes.
Okay.
Then he slides
And is
back.
it possible that at some point he was here?
Sure.
And how about, is it possible that at some point during that dynamic altercation he was even this far down?
It's possible.
When he's this far down, just over the thighs, where is that hip holster? I'm not going to ask you to get up. Just tell me when to stop my finger as to where the hip holster is.
Stop.
Right here.
Yes, sir. Right at the hip
Available to
line.
Mr. Zimmerman at that point.
Yes, sir.
Is it available to him at this point?
Yes, sir.
How about up here?
Yes, sir.
At this point, where you say it's available, what is my tie pointing down towards? Can you
His
see
belly
that?
button.
My tie is pointing directly to the belly button?
Yes, sir.
Based upon your training experience, was there just, how much thrashing or movement was happening in that dynamic event between these two men at that point?
I would have to say a lot.
Was that evidenced by the contusions and abrasions on Mr. Zimmerman's head?
Yes, sir. In the clothing, showing the contact, the wet spots on the clothing. You know, I think that you're not going to be involved in an encounter like this without it being dynamic.
Speaking of weapons and available, we had talked about mass approach the witness. For a moment. Do you consider that this could be a weapon?
Yes, sir.
Could be a weapon?
Yes, sir.
Could be a weapon?
Yes, sir.
Most anything that you want to be a weapon could be a weapon, correct?
Yes, sir. I do training classes on improvised weapon systems. Anything can be utilized. Depends on how it's used.
You certainly agree that fists can be weapons, right?
Most definitely.
And you saw evidence of injuries caused by the weapon of a fist, right?
Yes.
And the weapon of concrete?
Yes, his head striking the concrete, yes.
And just so we're clear, did you see any evidence of any injury on Trayvon Martin from your review of the autopsy that was consistent with him being hit by this?
I didn't see anything to that effect, no, sir.
Did you see any evidence of any injuries of Trayvon Martin being hit by anything?
I didn't note any injuries on Trayvon Martin, except for there was the one point on his hand.
How do you explain that fact to this jury? How do you explain the fact that in an ongoing altercation, I'm going to presume for the point of this conversation that it was Mr. Zimmerman screaming, just for this.
Yes, sir.
And it was Mr. Zimmerman screaming for 40 seconds. How do you explain to this jury that he couldn't even land a strike in defense of himself?
Well, if you,
Does that object to that? It's called for speculation.
Your Honor, I would ask.
You're asking for an explanation?
I am, and the door has, I think, been open as to potentialities that would happen between the two that night by Mr.
I'll
Guy.
overrule.
can you restate the question again? I'm sorry.
Sure. Can you explain to the jury a couple of facts? I'm going to suggest that it was Mrs. Zimmerman screaming, and you've now testified that Mrs. Zimmerman was not able to strike nary a blow on Mr. Martin. Can you explain to the jury how that might have happened, how that occurred?
Well, if we were saying that he's the individual screaming, then we could conclude that with Mr. Martin on top of him, Mr. Martin was the aggressor, the strikes were being rained down, and he, for lack of better words, was physically incapable of responding, screaming for help, wanting somebody else to help him out of a very bad situation. And it's possible that his hands were busy. They were, maybe they were pushing, I wasn't there, so I can't say exactly what his hands were doing. But I know that if you're the aggressor in a fight, how can you be the aggressor and not hurt somebody? So in this situation, if he's the one screaming, the reason that there's an absence of injuries is because he wasn't the one throwing strikes.
Is it unusual for someone to simply be completely dominated by another one who is physically better abilitied?
It all goes back to mindset. And it's not unusual, but what really, in listening to the non-emergency call that Mr. Zimmerman made, then it's clear during his conversation that he becomes concerned about Mr. Martin, especially when he's looking at him and walking back toward him, because he even vocalizes this to the dispatcher. He didn't get out of the car at that point to confront him. To me, my perspective is because Mr. Martin is not the I'm-in-your-face confrontational person. When he had the opportunity where he mentioned that Mr. Martin had taken off running, or I'm sorry, Mr. Zimmerman's not confrontational, when Mr. Martin had taken off, and he announced that they took off running, if that's when he gets out and he, is following, and the operator asks, are you following me? He says, yes, I am. It's because there's no threat. He took off running. Everything about that one call that leads up indicates that he had concern about his safety. I can hear it in his voice. Then when he interacts with him and he's coming back and he's face-to-face with somebody, he's not confrontational. He's looking at me. He starts talking about and you can hear it in the voice that he's talking to the dispatcher. And then when Mr. Martin's leaving again, suddenly his vernaculars strengthen, and he struck me as the type of person that doesn't have a problem telling you that somebody's a jerk, but he doesn't want to tell them that. So I actually lost the question. I'm sorry.
That's okay.
I
I'll
apologize.
refocus
I
it.
know I was going somewhere. I just don't remember where it was.
I was just going to let you go, but we'll
Thanks.
refocus it. Let's start where I was going to.
Let me ask you a question. We we have plans for the jury to go out for lunch, and it's going to take an extra long lunch time. Is this a good breaking point?
It is, Your Honor. Thank you.
Thank you. Ladies and gentlemen, if you'll, as you're packing up your stuff, I'm going to remind you that you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to get on the internet to do an independent research about the case, people, places, things, or terminology. And finally, you're not to read or create any tweets, emails, text messages, or social networking pages about the case. I have your assurance that you'll abide by these instructions? Yes. Okay, with that, put your notepads down, follow Deputy Jarvis, enjoy your lunch. We'll be back at 1:45. Please be seated. Mr. Root, during the lunch hour, you're free to go about your own business, but you are not free to talk to anybody about your testimony. That includes the lawyers, okay? We'll see you back at 1:45. Is there anything we need to take up before we recess for lunch?
No, Your Honor, there are a few things that we have stipulations for entry, but I can do that at any point during my case.
Okay.
Maybe when we get back or afterwards.
That will work. Thank you. Court is in recess.